Good morning. I'd like to call this meeting to order. The time is 9:03. Today is December 6th. God, time is flying. Friday, December 6th, 2024. This is the second day of a 2-day meeting of the Physical Therapy Board of California. Today, we are meeting in the hearing room at the Department of Consumer Affairs building located at 2005 Evergreen Street in Sacramento, California. This is an official business meeting of the Physical Therapy Board. The board's role remains to maintain consumer protection and consult with local and state entities on the laws and regulations pertaining to the physical therapy industry. We will take public comment on specific agenda items, and at the end of the meeting, there will be a comment session for items not on the agenda. Public comments must be specific to the agenda item that is being discussed. If you make a comment during a specific agenda item that is not related to that topic, you will be directed to hold your comments until we reach the appropriate agenda item. All comments that do not directly relate to an item on the agenda should be held until the agenda item for items not on the agenda. The board follows the Open Meeting Act, so while we accept and appreciate the public's comments, we cannot respond to those comments. This meeting is being recorded and minutes of the meeting will be prepared. Can we please have roll call?
Tanya McMillian.
Present.
Dale Armstrong. Dale Armstrong is absent. Karen Brandon.
Present.
Katarina Ellaby. Katarina Ellaby is absent. Sam Q.
Present.
Alicia Benemen.
Here.
All members are present with the exception of Katarina Ellaby and Dale Armstrong, and the board has a quorum.
Thank you. May I please ask member Sam Q to read the board's mission statement?
The mission of the Physical Therapy Board of California is to advance and protect the interests of the people of California by the effective administration of the Physical Therapy Practice Act.
Thank you. So we're going to go along with our agenda item number 16. I'm going to ask all of the board members if you could please take a seat in the audience with the exception of our legal counsel.
By the Chief of the Division of Investigation, Kathleen Nichols and Emily Kendricks. And if you'd please come up and introduce yourselves, and the PowerPoint is ready for you.
Good morning. I am Chief Kathleen Nichols with the Division of Investigation, and also with me is Northern Area Commander Emily Kendrick. It is our pleasure to provide the board an overview of the Division of Investigation and the services that we provide to the Physical Therapy Board. The Division of Investigation was established by the legislature in 1961 to provide centralized investigative services to the 36 boards and bureaus of the Department of Consumer Affairs that regulate over 3.4 million licenses and more than 250 various professions. The vast majority of our investigators are sworn peace officers pursuant to 830.3 of the California Penal Code, who perform a full range of peace officer duties and responsibilities. The division's mission is to provide exemplary law enforcement investigative services to protect consumers. Our employees have a true passion for consumer protection. I've worked for this department for over 29 years, and it is an honor and a privilege to protect consumers and to conduct fair and unbiased investigations. When we hire new investigators, we were looking for those who have a genuine interest in these type of cases, who will go the extra mile and be resilient when faced with obstacles. And committing to give their best every day. This is not an easy job. The caseloads are high. There's a lot of stress involved. A lot of these cases sometimes involved a lot of harm and sensitive issues. But it's a very rewarding job. And it means a lot when we can do right by the consumers, the patients, and also the licensees by conducting fair and unbiased investigations. Our peace officers conduct criminal and serious administrative investigations. We make felony and misdemeanor arrests and file criminal cases with the local DA's office and administrative cases with the Attorney General's office. We work hand in hand with other law enforcement agencies. We write and serve search warrants. We conduct undercover and sting operations, and I have to say that's probably the most fun part. We have really cool equipment that records audio and video, so we will go in posing as patients, and we are able to record and take video of those encounters. So the investigators will tell you those operations are fun to plan, they're fun to do, and they're great evidence when we go to court. Our investigators receive over 600 hours of training to become peace officers and receive ongoing training each year regarding specialized investigative topics. And we also attend ongoing quarterly tactical training. DFI, the Division of Investigation, has 3 main units. The Investigation and Enforcement Unit, known as IEU, they conduct the investigations for this board. The Health Quality Investigation Unit, HQIU, which was formerly housed at the Medical Board, and the Special Operations Unit, SOU, which handles internal affairs investigations, CORI clearances, and workplace violence matters for the entire Department of Consumer Affairs. I'd like to turn the presentation over now to Commander Emily Kendrick, who will give you some more details regarding IEU, case prioritization guidelines, and some statistics for our work with the Physical Therapy Board.
Thank you, Chief. So IEU, we provide sworn law enforcement services to many of the boards and bureaus under DCA, and we have 8 field offices statewide. We have 4 in the northern region, which we have 2 in Sacramento, 1 in Concord, and 1 in Central Valley. And then we also have 4 offices in Southern California, in Chatsworth, Ontario, Cerritos, and San Diego. In conjunction with our Investigation and Enforcement Unit, we also have our Enforcement Support Unit, and that is comprised of our case intake and investigative support staff, as well as our special investigators, and those are non-sworn investigators who provide investigative services for both IEU and HQIU. So we have, as Chief mentioned, we do criminal and administrative cases. And so some of those will be acts of serious harm, injury, or death. We have gross negligence and incompetence, sexual and physical abuse, controlled substance diversion or theft of narcotics, practicing while under the influence of drugs or alcohol, unlicensed practice, as well as media and politically sensitive cases and allegations of fraud. So most recently, back in March of this year, we rolled out our new case referral guidelines, and this is new. They're broken down into 4 categories. Our first category is our urgent cases, and these cases are immediate referral over to DFI. Our second category is our high priority cases, and those are going to be cases that the board will have communication with DFI to make sure that those cases do indeed meet the guidelines for referral. And then categories 3 and 4 are all other cases that don't meet the guidelines for categories 1 and 2. But in category 1, just some examples of cases that would meet the urgent requirement is mental or physical impairment of a licensee with potential for public harm, practicing under the influence of drugs and alcohol, theft of controlled substances, or diversion of controlled substances, physical and mental abuse of a patient resulting in great bodily injury, death, or both, felony criminal violations not currently being investigated by another law enforcement agency. Those are just some examples of our category 1s that require immediate referral over to DFI. And again, our category 2, which are the high priority cases, these are ones that the board will consult with DFI prior to sending over, just to ensure that they do meet the criteria. And these cases are the quality of care complaints of serious patient or consumer harm, gross negligence, incompetence resulting in great bodily injury or death. And then again, our category 3 and 4, those are going to encompass all the other cases that don't fit into categories 1 and 2. And this really is an opportunity for the board to have more autonomy on investigating these cases on their own without having to refer them over to D of I. This news release was just published a couple weeks ago on November 26th and really highlights the partnership between the board and D of I. This case was one in which a physical therapy assistant was investigated and subsequently convicted of sexual battery, has been now sentenced to 1 year formal probation, has his license revoked, and for the rest of his life will have to register as a sex offender. But this really goes to show the quality and the good work between both the board and D of I and the results that come with these investigations. And then here are some stats, just reflecting, the top portion reflects how many cases over the past 3 fiscal years have been referred from the board over to D of I. Currently, we have 82 open investigations for the board. And then the information below shows how many days it's taken us from the time the case was open until the time it was closed to work these cases. And for the board particularly, our objective is always to try to work these cases within 1 year. And currently, IEU has approximately 1,100 open investigations between all of the boards and bureaus that we service. Again, 82 of those are physical therapy board cases. So we're very proud of the fact that we've been able to achieve our goal of making sure these investigations are completed under that 1 year mark. Any questions?
On the last slide, out of 1,182 are PTBC cases, and that seems like a high percentage of PTBC cases. Is that correct?
I think if you looked at just the cross section of license types and the licensing population amongst all the different boards and bureaus, I'd agree the percentage does seem kind of high. But if you look at the sensitivity of the types of cases that we're talking about, the complexities that healthcare brings, physical therapy is a very touchy-feely art and science. I think that probably explains the anomaly more than anything else.
I just want to add, as a consumer of services, I don't always see or hear the notice to consumer as obviously as I hear it in our field, physical therapy. So I just wonder if that increased knowledge that you have a right to complain, if that comes across in any way. But I don't know, just speculating.
I wanted to ask if this is an extension of the Department of Justice, or if this is like a crossover between the medical field and Department of Justice.
So D of I is completely separate from Department of Justice. We're housed under the Department of Consumer Affairs. That's our umbrella. And Department of Justice is a separate agency. They also investigate healthcare fraud. They have a unit that does specifically fraud. But as far as the actual case types, we're not affiliated with Department of Justice, although sometimes we do work cases with them.
Okay. How would somebody get into this kind of work if they were interested?
This is a very exciting job, I have to say. In the 29 years I've been doing it, every single case is a little different. You never get bored in the sense that there's certain case types, but the facts of each case are always different. And recently we were successful in changing the minimum qualifications for investigator. It used to be you had to have a criminal justice degree and or experience. Now we've changed the requirement, so it's any 4-year degree. So you can have any 4-year degree and you can apply to be an investigator. We are putting people through the academy as well. I mean, we'd like to hire people that already have their police academy, of course, and experience. But we recently, just a couple weeks ago, 4 of our candidates graduated from the police academy. So we are sponsoring people through. So it's a good opportunity. And there's offices all throughout the state. You work a variety of case types. And like I said, the variety is just unheard of every single case is different. And you really do get a satisfaction when the cases are over and you see the results that you're actually helping people. And in a lot of our, we have some prior law enforcement, they've worked maybe say 20, 30 years at LAPD, they retire and come work for us. But those that have retired from law enforcement jobs and work for us say, not only is it the hardest job, like they think it was going to be easier, so it's not a cushy retirement job by any means. But they say that just the impact that it has on protecting people is often equal to first responders who arrive, to regular police calls. So it is very, very rewarding, and it means a lot. I've gotten letters from patients that are just so thankful, that we've listened to them and looked into their complaints. And also from subjects, because I think sometimes we forget it's important that we're also doing right by them as well when we do our investigations. Nobody's rushing to judgment. Our job is to get the facts, to get all the interviews and evidence, and then it sorts out in the end based on the facts.
That makes sense. Fantastic. Thank you.
Thank you for your presentation. Question, how many boards are you covering? You mentioned it at the beginning of the Healing Arts.
So for the IU unit that handles the physical therapy board cases, there's 36 boards and bureaus within DCA, and IU handles all of them.
Okay.
And then the HQAU unit, they handle only cases for medical board, podiatry board, physician assistant board, and osteo board.
Okay, so excludes us. They're not.
HQAU, that unit in particular, doesn't work physical therapy board cases, only the IU unit does.
Got it. So out of the 30, my question is about the process after a complaint comes in. Do all of those 30 odd boards have very similar process? Do they have their own investigators? Like I see here and it looks like March 2024, there was a request or a notice that there would be triage, right? That's occurring. But I was just wondering, do all of the boards have the same process when a complaint comes in, and do they have the ability to do category 2s and 3s and 4s?
A lot of the boards have their own special investigators. And so what happens sometimes is if they get a category 3 and 4, they just keep it because their special investigators can handle it and they don't need to refer it to DFI. But one thing that we've done is we have a very small non-sworn unit. We have 3 non-sworn special investigators. So when smaller boards that maybe can't afford to tilt up their own program of special investigators, they still would have the opportunity to refer those cases to DFI. But as far as the process for processing complaints, every board's a little different, but they pretty much follow the same process. Everyone has an intake unit. They screen the cases. Our intake unit at DFI has a lot of communication with the boards and bureaus about cases. One will come up and it'll be like, ooh, should this case go to DFI? Should it not go to DFI? They have weekly meetings, sometimes monthly meetings, whatever the board needs to keep that triage going.
Kathleen, I was hoping that you might be able to describe maybe some of the differences between PTBC's specific mandates when it comes to investigations. As an example, DFI investigators working with an expert consultant with the board, and how early that kind of process is for us just based on our legislation.
Right. So each board does have its own different nuances, and that's one of the things with the physical therapy board is very early on, our investigators work with the physical therapy board staff, and they do go out and do joint inspections. And we recently had training that physical therapy board put on with the AG's office and kind of for all the investigators to kind of go what that process is. Other boards similar would be the veterinary medicine board. They also have medical consultants or consultants that go out with the investigators to do inspections at the actual facilities.
I've always been curious what that looks like. So a complaint comes in and maybe a physical therapist has been allowing an aide or a physical therapist assistant or whoever's sitting at the front desk to provide patient care, and then the patient complains. And so what does it look like when you arrive at the site? And are they given notice or do you just come in?
So in those instances, typically, our investigators will gather the information, but we have a lot of communication with board staff to coordinate with an expert to go in with us. And we will go in unannounced and just let them know, hey, here's who we are. This is what we're going to do. The board's expert will handle reviewing all patient records and those tasks, because we're not, as investigators, allowed to have that information, but the board's expert is. And so at that point, we'll go and interview staff while the expert's reviewing those records. Sometimes the expert will let our investigators know, hey, I've seen this. This might be a good question to ask. So there's a lot of collaboration there between the expert and our investigative staff. And then at the end, the board's expert will write up their report, but they'll also provide us with patient information for any records that they reviewed that the board is going to need to evaluate to determine whether or not there's, misconduct or whatever in conjunction with our statements that we received. And then we submit our report back to the board, and the expert will make the final, determination on wrongdoing.
I was just going to ask, based on that, what's the jurisdiction? Is there a warrant for the gathering the data, or even? Yeah, I'm just trying to understand the process.
Yeah, right. No, there's actually there is legislation, or there's in the Practice Act, there's I don't know what you call it, a code section that allows for open inspection of records. So, and that's specifically by an expert for the board. Whereas again, we don't have authorization to go in as sworn officers to just look at the records. That's why the expert is there, and they do that. And then once they determine, they provide us a list of just the contact information of the patients whose records they reviewed. Then we will contact them and say, hey, we would like to obtain a copy of your records. Here's what we're going to, here's what we do with them. We provide them a privacy notice that explains exactly the purpose of what we're going to use their records for. And then if they sign it, great. If they don't, then we go through the subpoena process to obtain those records. So then we can supply those to the board.
So is it just two of you who are going in usually, or is there anyone else?
Oh, it depends. It depends on just basically the intel that we've gathered from just the ongoing investigation. The expert will always be there, and we always stay with the expert just because we will never leave them there by themselves, just for safety purposes. But we typically, depends on the size and how many people we need to interview. A lot of these businesses are very large and they have a lot of different people. So we may have at least 2 sworn staff along with the expert to try to just, minimize the amount of time that we're there and minimize the disruption to the practice.
Yeah, I just add that there's some logistics to consider in every time that we are going to do a site visit. And sometimes the site visits are unannounced, but depending on the case, we might actually let them know that we're coming out to do record review or something like that. Officer safety considerations, expert safety considerations, how many interviews are going to be conducted, how large is the facility, all of those things have to be considered in determining what kind of staffing is going to be used on a site visit.
And typically the board staff will let us know, hey, we've reviewed this, we would like to send an expert out. And more often than not, they've already coordinated it. So it's a great, we already know who we're contacting and who we need, and they're expecting our call to schedule and coordinate to go out to these facilities.
Before I hog the mic, anybody else have a question?
Yes, hi. I do have a question in regards when you guys do a site visit. Is the clinic allowed to still maintain their normal day-to-day basis, or do they have to shut down?
That's a good question. I guess it depends on what's going on. If it's, say it's an allegation, we're going to go in there and somebody's alleged to have been under the influence of, narcotics or practicing while they're under the influence, that it may disrupt service for a moment, because we're going to say, hey, we'd like to drug test you, come with me, and we'll get this done right now. And it's on site, so they're not leaving the facility. Typically, we try to be as undisruptive as possible when we go in there. We're going to be doing a lot of observation too. The expert will be observing if it's, who's doing what services and whatnot. But no, we don't go in and just say, hey, you're shut down. You can't practice anymore. I guess there's a lot of what ifs, right? It's not an all-inclusive or all-encompassing, response. But if there's unlicensed practice occurring, where there's no physical therapist on site, you've got somebody who doesn't have any sort of license, we will tell them, you can't do this. You know, you can't continue practicing. So, and if we come back, you know, sometimes it's a citation because we can issue misdemeanor citations. Sometimes we rely again on the expert to opine whether what they're doing does constitute, you know, physical therapy practice. But oftentimes we'll say, hey, you can't do this anymore. You can't see any more patients today. If I come back, you know, we don't want to see you doing this. So it depends. It's all situational. A lot of, you know, things go into that.
Yeah, I would just add that the site visit almost always is very preliminary in the investigation. So we're trying to keep it as kind of low profile as possible, but circumstances can dictate otherwise, right? And so if it's something that it's later on and we have to come in and it now turns into a subpoena search warrant situation, which essentially makes that practice, for lack of a better definition, a crime scene, we'll probably shut that facility down for that period of time for a number of different reasons. One, evidence collection, but also just officer safety. The initial 99% of the site visits are, you know, we're not trying to shut the business down. We're not even trying to disrupt patient care. We're just here on a fact-finding mission.
So when we are students, we do have law and ethics in the curriculum. And one of the things that we remember usually is, you know, dot your I's, cross your T's. You don't want the state to show up at your door, right? And then once you're practicing, you're thinking the same thing. I don't want, if the state were to walk in at any time, would you have all your ducks in a row, kind of a thing. And so if someone in your facility is being investigated, are your records also fair game to be looked at? Your documentation?
When we go in and do an inspection, all records are open to inspection. So it's whatever's maintained at that facility is open to inspection. Yeah.
All licensee documentation, right?
Patient
So not
record.
patient records, yeah.
Yeah.
The statutory authority that's granted in the PT Practice Act says that the board members or a licensed designee by the board has inspection authority. And so that is for anything that would be considered physical therapy records. Physical therapy records can stretch into flow sheets, exercise sheets, business schedules, those kind of things. So there is quite a breadth of documentation that needs to be reviewed on any given case.
Well, thank you very much.
Madam President, we take a brief recess while we put everything back together.
Yes.
10 minutes.
We'll be back. Everyone can be seated. We'll get the ball rolling again. So there will be a slight change to the agenda. So we will do agenda items 17 and 18, and then we're going to move up the student Q&A, which is item 21, after the licensing services update. All right. Okay, so next on the agenda is item 17, the administrative services update. And I think, Jason, you're going to share that with us.
I am. Let me just get my materials up real quick. So I'm going to be subbing in for Liz Constancio. We had a lot of what would be considered some of the admin report yesterday with the Department of Consumer Affairs Budget Office coming in and doing presentation of services. So I'm going to pick up on some of the other things. 4 program updates for the Administrative Services Unit. Again, as we heard yesterday, the board is continuing to work under the directive of the Department of Finance's issued budget letters 2327. Again, that directs all entities under the governor's direct executive authority to reduce last year and this year's expenditures to address the state's general fund budget deficit. DCA has been very helpful in working with us to meet our operational needs. We've realized where those 8% cost savings can be identified. And again, as reported yesterday, we're lucky enough to not have lost any position authority for staffing as of yet. And knock on wood if you're with me. Travel, there's nothing new to report on travel. Training, though, training has been limited as a result of those budget letters to required training only, and we are utilizing DCA's solid unit for our training needs. We will continue to explore options for training that's not job required and not offered by solid. There's some specific trainings that, as it pertains to investigations and even communication and customer services systems that we're interested in and looking at. And to date, PTP staff members are in compliance with their mandatory training and reporting requirements. Having said that, we do have a few outstanding training requirements for some board members, but we'll discuss that at a later date. For personnel, the PTBC has authorized 29.1 positions. For quarter one, the PTBC has 2 vacancies, as I mentioned yesterday, and we have made 1 appointment. The admin unit also welcomed Ashley Marino on September 16th. Ashley reporting to the admin unit, but will be working with all of the units within the Physical Therapy Board on things like efforts to go paperless and maintain the board's electronic files. Ashley's been doing a great job with assisting us in meeting our goals. We're currently recruiting for 2 permanent full-time positions, 1 analyst within the admin unit and 1 analyst within the continuing competency unit. The board does anticipate the recruitment to be completed within the next 90 days. Asset management, Liz previously reported at the September meeting that they conducted an asset management audit of PTBC internally. Vincent Azar conducted an audit on all board's assets and is now finalizing that survey and also surveying old and obsolete equipment. And Liz specifically would like to thank Vincent and Ashley for all their help on that project. That wasn't an EG project. It's kind of like a spring cleaning kind of thing, and we haven't done it in quite some time. So we have one room that kind of looks like an IT graveyard right now. ADA compliance, PTBC isn't current with its meeting its ADA compliance requirements, both on documentation and on the board's website. And then IT and program management. Liz previously reported the admin unit had fully transitioned to SharePoint, and now the executive unit is going through that process as well. And Vincent is currently working with the enforcement unit and will be working with the continuing competency unit to transition to SharePoint as well. Records management, admin unit, newest member Ashley Marino will be working on scanning, recording, and purging the admin unit's files and following the retention schedule. Once she's completed, she'll then move on to the executive unit's record maintenance and then the next unit, so on and so forth. For the budget, the Physical Therapy Board is authorized a $7.2 million budget this fiscal year to support program requirements. This includes personnel services, operating expenses, and equipment. There was a small decrease of about $30,000 in our budget authority this year because our authority had increased over the past 2 fiscal years to cover the initial cost of our 2 BCP positions. Within applications and licensing, that total comes out to about $267,000 for 23-24 and about $251,000 for fiscal year 24-25 and ongoing. While the board has authorized certain allotments per line item, we discussed this a little bit yesterday, we make internal adjustments within the operating expenditures to align with the board's projected year-end expenditures. Those line items include under expending one particular line item to overexpend another, if you will. But the board works off of baseline budgeting, so any internal changes made to realign our budget line items are not permanent. We'll continue to work with DCA and the budget office on aligning those line items and acquire appropriate funding for those line items in the future. For expenditures for quarter one, we did spend $2.1 million. Comparing that to revenues, we collected 2.5. So to kind of the conversation yesterday, we do live within our means at that point. So one note during the last board meeting, though, is that Mr. Quee had asked why the initial licensing fees had decreased from previous years. And again, we discussed this yesterday. Looking back at it, the bounce back came in to the next quarter reporting. So it just depends on a graduating class, if you will, when that graduating class hits. The PTBC fund currently is projected at 8.2 months reserve and 7 months reserve by 25-26. And again, those numbers will change as we close out 24-25 fiscal year and are reassessed every November. It was discussed yesterday during the budget proposal. And that is it for the admin services unit. Any
Thank you.
questions?
Thank you, Jason. Can you please explain what the ADA compliant website can offer for users?
So there's a couple different things. One is any publications that we put out onto the internet have to be accessible by those that are both vision impaired and so can be read by a digital or a software screener. And even the documents that we prepare and post and provide to the public about things like disciplinary orders or probationary orders, those also have to be. And if you think about the nature of those kind of documents, sometimes those documents come to us from courts all over California, all over the United States for that matter. And what we have to do at that point is then convert them from essentially what is a picture of the document and make that document text recognizable for those readers to be able to read that same document to somebody who might have a vision impairment kind of issue. It's a slow, kind of drawn out process. Every document is slightly different. They come from all different directions. They're all formatted slightly different. So staff, with the help of Vincent and a few coordinated people in each of the units, is tasked with making sure that those documents are ADA compliant before they're posted to the website. And then the Department of Consumer Affairs Office of Information Services also kind of keeps an eye on that, helps with the conversion of those documents, but also kind of does an audit to see if anything kind of slips through. Another good example of ADA compliance is even the agenda materials that were sent out for this board meeting, right? When they're created, they may not be quite ADA compatible or compliant, but once we publish them and post them to the website, we need to make sure that they are.
Second question would be about the budget.
Council might have.
Oh,
Okay.
go right ahead.
Well, I was just going to add that in terms of the ADA requirements, that the ADA has recently, and I say recently, it's kind of relative, probably in the past 10 years, litigation has established that that type of website accessibility is required under the ADA. And so slowly but surely, state government has been moving in that direction.
The only thing I'd add to it too is we also have a section on the website carved out for ADA accessibility so that if somebody who does come to the website has a difficulty with anything, there is a designated point of contact that will help them with any of those kind of requests. So
That's great. And for the budget in the briefing paper, I don't see any mention of our fund condition.
So the fund display that's provided to us by the Department of Consumer Affairs Budget Office, depending on when we have a board meeting on the calendar, sometimes that's available for the day of publication for materials. We don't have the fund condition from budgets as of yet. The estimates that I read to you are a combination of projections provided by them and kind of our own in-house calculations. But as soon as I would expect that for the March meeting, we will definitely have a more current display of the fund condition.
And can you give us an idea of what it is?
8 months currently.
8 months.
Yeah.
Thank you. Thank you.
It's 8 months currently, but moving to a 7-month fund condition for the next fiscal year.
Thank you. Last question is actually a question for Board Member Q, and that is, I'm going to lean on your expertise and ask if, you know, you've been looking at these reports now for a little bit, and ask if there's something or some display that you feel might help board members in the future, like a balance sheet or something like that. I mean, I'm sure you look at this and you're like, oh yeah, I could read this. This is great.
Yeah, based on my review, the balance, there's really, for the board, there's really no balance in the state because and the income statement is what we're really looking at, and the question regarding the reserve really is your balance sheet, right? That should really tie to whatever cash you have, which is probably invested with the pooled with all the investments that the state has, and from a sort of accounting point of view, a 7-8 month reserve it's pretty healthy. Anything over 6 months is considered pretty healthy. I mean, just to explain that sort of in an easier term, is that you basically have 6 months of cash with you that covers all your expenses. If you put it in a personal way, that'd be 6 months of reserve for yourself, and you can carry out your living without having to tap into anything else. So does that help? Okay.
Just for the purposes of audiences, the Physical Therapy Board is a special fund board, so we don't receive any taxpayer money. All of the monies that we receive come from the applications fees that we collect for the application process, and then ongoing renewal process for licensure renewal for licensees. So the 29.1 staff, the building that we reside in, all of the benefits and retirement, the equipment, furniture, any of those kind of things, all of those expenses account for that budget. And to Mr. Quee's point, the fund condition that we're referring to essentially means that if we stopped receiving monies today, meaning that no renewal fees were collected, no application fees were collected, we could continue to exist for about 8 months. We have just enough in the fund to keep us afloat. We are about a mid-sized board, relatively speaking, in the Department of Consumer Affairs. And there are things that can be seen as kind of unforeseen circumstances, costs that we did not anticipate. And one of those things very clearly is just our enforcement program. The presentation that was just given with the investigation, cases can get very complex, can involve a multitude of patients, can involve a multitude of victims in those matters. And when those investigations run long, those costs obviously kind of rack up. But they're necessary in just ensuring that that case meets an evidentiary standard and that recourse is given to the consumers in those situations. So $7.2 million sounds like a large budget for a regulatory board. Again, it's all relative, right? If you look at the Medical Board of California, you'll see that their budget is about, well, I wouldn't hazard a guess. I would say 10 to 15 times more than what we spend. So, but just know that the purposes of displaying this information to you at a public meeting is that we have to provide this. We're required, right? We have an obligation to both our applicants and our licensees to be as transparent as possible, and you guys can all see where the money gets spent and how it gets spent.
Thank you, Jason. Any further questions or comments from the board? Any public comment?
You're all included as members of the public.
Yes. Okay. Hearing none. Nope. Nope. Okay. All right. So we will move on to agenda item number 18, licensing services update. Hi, Valerie.
Good morning. Good morning, Valerie Kearney, Licensing Services Manager. I'm pleased to announce that Andrew Caton joined the applications unit this October 14th. He will be processing U.S. new graduate PT applications, sharing that workload with our current U.S. new graduate PT applications analyst. Application services, initial license applications received increased by 14% from fiscal year 23-24 first quarter, with physical therapist assistant PTA applications received up 28% overall from quarter one the previous fiscal year. We expected that increase in PTA applications because PT programs have been added for the last several years throughout California. Of the 830 initial applications received quarter one, 94% were U.S. Educated, with 73% exam applicants, and 27% were by endorsement. Foreign educated and military applications were 8% and 2%, respectively. And initial application processing times were at 30 days. Initial, and I did want to just kind of clarify that 30-day processing time. That is the time that it is actually our responsibility working on the applications. If you think about it, when an application has two people responsible for its completeness, the board does our part, and then also the applicant must do theirs. So, for example, the most common delay of application processing time is fingerprinting or inability to pass one of the exams, which now is pretty much just the National Physical Therapist Assistant or National Physical Therapy exam, because the CalJAM is getting a pass rate of about 98%. So overall, though, the application is within the board's hands for about 90 days, but 30 days of that is actually the time that we are responsible for completing it.
Can I add to that, Val?
I'm sorry?
Can I add to that? I just
Yeah,
want to add
please.
a small bit. So I guess this kind of goes back to some of those conversations that we've been having about performance measures as they relate to licensing.
Thank you.
For the audience again, right? When it comes time for you to be an applicant with this board, the more prepared you are with your application, meaning that you're submitting that application with as few deficiencies as possible, the more timely your application will be turned into a license, right? To that point, what Valerie's basically saying is it's almost like a chess clock. There's about a 90-day period from an initial point of receiving the application on average to the license being issued. Of that time, the responsibility that we can identify being with the board is only about 30 days. So that other 60 days kind of boils down to deficiencies that were in the application when it was submitted by the applicant. Or, and this is for the board's advantage, more importantly, the delay and the availability of when the MPTE can be taken, when you can actually sit. It's only given 4 times a year. There's kind of a 90-day window in between each examination. And just from a very kind of cursory review of that idea, it seems like the fixed date testing schedule is actually the biggest hindrance towards an expedited license.
Excellent. Thank you.
Valerie, can I ask a question, please? I'm going to take us back to pre-Breeze, and Breeze is the platform that we use to apply and to renew our licenses and that sort of thing. Pre-Breeze, we were all on paper. I don't know how long this process took. I'm guessing it was Sarah Conley. I'm sure it was more than 30 days. My question is, before we were on Breeze, there was a thought that because this is a program that's automated, that once that NPTE score was entered, the license would be issued. But I don't think that's necessarily the case. Is that correct?
It can be, assuming that all of the other deficiencies in the application are already fulfilled. If as an applicant, you've provided the board with everything that they need to determine whether you're qualified for licensure. And some of those are basic, a passport style photo that's acceptable. Your fingerprints and your fingerprint background check has come back without any kind of issues or concerns that need to be looked at by the enforcement unit. The application questions are filled out completely. Breeze handles a lot of that now because it won't let you move through the process and let you actually answer the questions most of the time. If the only deficiency is either the jurisprudence exam or the National Physical Therapy examination, there's one, I guess, last stopgap measure, and I would describe it as in the checklist, there is a ready for licensure tab that the analyst can check. But if they check that and then the score comes in, the license will issue overnight.
Oh, yeah. So part of my question comes from actually wearing the hat of DCE at a program, and of course the students they receive great guidance from the board, and they receive very timely communication from the board when they call, when they email. So thank you very much. And sometimes after they take the NPTE and then get their score, because I think they get it before you get
Absolutely.
it, or we get it.
It's actually that probably is fixed at this point. Early this year, we went from an interface system with FSBPT to an API that delivers the results almost automatically. So as soon as FSBPT makes them available to us, they are downloaded to the applications. And in fact, the old interface system only ran on Friday nights at midnight. The new API is every day at midnight. So I think it's been fixed. I know we used to have some real problems early on with the interface, and poor PTAs, they usually got it first because they take their exams the first part of the quarter, and we can get it fixed by the time the PTs take their exams. But that first exam was almost always human error was involved. They had to send the right file to the right section of the interface for it to download, and it just wasn't getting done. And then we'd have to have it fixed. Sometimes it would take a week, 2 weeks to get it fixed. And we don't have that problem with the API.
That's great.
So I think that has probably been resolved, but we have not had any issues with it since about the June exam. I think April was the first one that the API was in. It was still had a few bugs, but the June exam went through smoothly.
There is a small caveat to that, though. You might still hear from your students, or you as applicants, when you get to that part of your application process. When you sit for the exam, you have a little portal, you have a website access on your cell phone, and you'll get a notification, congratulations that you passed. You'll get that notification, from what I've seen, sometimes same day or next day as a result of sitting for that exam. We, the board, will not receive that same score report, even through the API process, from anywhere from 7 to 14 days.
Correct.
The Federation is actually, the facilitator of that examination is going to hold their scores because they want to do a forensic analysis of those scores to determine if there are any kind of anomalous, they're looking for cheating scandals, right? They're looking for some of the people that got in a graduating class, every person in that graduating class got this question right, but they got this question wrong. So where did that come from, right? So they're going to do that forensic analysis. Once that analysis is complete and they're confident in those scores, they'll release them to the jurisdictions. And that's not just California, that's nationwide. So there is a small gap. The API, though, is essentially a protocol of software that allows the Federation's software to talk to the state's Breeze system software. And so they can, where we used to have to do this kind of automated running of a report every Friday night, and it would sort the scores, and sometimes there'd be fallout. The API has much better mapping and is more instantaneous and works both ways. At the same time that they're sending us scores, we're also sending the Federation data on things like license status changes, and it's real time. So it's just a better way to do business.
And there are still opportunities for error. For example, if it matches up by name, social security number, and date of birth. So if for some reason the applicant has typoed the wrong date of birth or the wrong social, and we didn't catch it, which doesn't happen often, but we do sometimes, that score will not download to the application, then we have to go through it manually, which of course would delay that. But overall, the API is working very, very well. And speaking of exams, I want to call your attention to the exam statistics report. The reason for that is that I have added the national JAM as well as the national law exam scores for comparison with our own. And you will see that for the California law exam is still on the exam statistics report. That's because we had a couple of people, 27 to be exact. 22 took it in July. They just decided not to transition to the JAM, even though the JAM was available. 22 took it in July, and 8 took it in August. By the way, 19 of those passed and 8 failed. But that's mixed in with the JAM scores, and that's why Cal Law is still showing up on there. Of course, next fiscal year that will be removed. Other than that, if you don't have any more questions about that, my reporting, I would like to mention that Continuing Competency has requested approval agency recognition removal for Synergy Education seminars.
Okay, any questions, comments, board members?
Valerie, I want to thank you for including the application services data summary. It's always interesting to me to see how many are seeking licensure through exam and endorsement, but
Thank you.
more than a quarter
Yeah.
for endorsement from other states. So
Yeah.
thank you.
We're finding that to be about kind of the common number, really, for about the last 2 years.
And it's pretty consistent. It isn't seasonal like new graduates.
Any public comment? Public questions? I am hearing none.
So there is one.
She needs a motion.
One point of business, and that's the briefing
Motion
paper
removal.
for the removal of recognized approval agency.
I don't mind making a motion to follow the recommendation of the continuing education unit in removing Synergy Education seminars from the approved agency list for PTBC.
I second.
We have a motion and a second. Any just further discussion? Public?
Yes. Hi. I had a question. What was the most common mistake that students make or applicants make on the application that delay the process?
Ooh. Valerie, do you
Valerie?
mind coming back up?
Oh, we do need to take a vote, and then we will we'll
Open it up
address
for
your
that.
question.
Sure.
So, Brooke, would you call the roll?
Tanya McMillan.
Aye.
Dale Armstrong. Dale Armstrong is absent. Karen Brandon.
Aye.
Katarina Ellaby. Katarina Ellaby is absent. Sam Q.
Aye.
Alicia Benamen.
Aye.
4-0. Motion carried to remove Synergy Education Seminars approval agency recognition.
Thank you. Back.
And may I amend your question to the top 3,
Sure, of course.
if you can do
Well,
it?
why don't you, counsel?
Are you done with me now?
No, so
Okay.
this question, and I'll just ask you to rephrase it so Valerie hears it.
Yeah, of course. I wanted to ask what the top 3 most common mistakes the applicants make on the applications that delay the process.
Yeah, that's a good question. I don't know that there's a whole three. The application process is all online, so basically, unless you almost can't answer a question incorrectly. That's usually not the problem. The problem can be anything from a fingerprint issue or on the applicant's part, not including their photo or copy of their completed live scan form. Delays can occur too. For example, and this doesn't happen often with California schools, but if, for example, you've already submitted your application, but the school has not submitted your certificate of completion form yet, that can be a delay, but it's not a deal breaker. We're still going to process your application. It just could take you a little longer.
No, that makes sense.
Through the software system, at the point of application, you're given the opportunity to upload some of these documents, the passport photo, your live scan form, those kind of things. If you don't have them at that point, all is not lost, right? You'll get a notification from one of the analysts at the board that there's deficiencies in your application, and you're given the opportunity to provide them at that point. So that kind of goes back to what I was saying, is the more prepared you are initially on initial submit, and that first time you enter into the system, the better. The system won't allow us to open the window back up for you to go back and do an upload process. You might be required to email them to us or mail them to us in hard form if you didn't do it at that one particular opportunity. So,
Are you with Unitech?
Yes, ma'am.
Were you in the class that we gave the presentation for?
Yes, I believe so.
Okay.
Yeah.
All right, you should have a copy of that application, of that presentation.
I do, yes.
Okay. It's lots of information in it, but you can also just email us. There's an email address in the presentation. Submit it. If you have a question, submit it there.
No, thank you so much.
We'd be happy to help you.
Appreciate it.
the only thing I'd add to it is maybe it's not the most common mistakes, but some of the confusions that can occur is just kind of knowing the difference between the Physical Therapy Board of California, the federations of state boards of physical therapy, because you register for the exam. And we've had confusions where applicants have said they thought that their registration for the National Physical Therapy Examination was essentially their application process. And so there's actually really nothing happening with us. We're not even aware of them. Nothing has been submitted. But somehow in that confusion, they call us to ask us about, like, what's going on with my license? And we're like, I don't know, what's going on with your license? Are you gonna submit an application, or, so again, few and far between. And it's not really, it's more about a confusion. It's not really a common mistake.
Right.
Right. Okay.
Yeah. And keep in mind what Jason was talking about was that you're going to be using 2 online presences throughout the application and then the licensure process. FSBPT.org is going to be all about your exams and exam scores, how to where you register, where you get your ATT letter, all of that kind of good stuff. Whereas ptbc.ca.gov and the BREEZE system is going to be all about your application and then your eventual license and license renewal and continuing competency. And it's going to be your best friend throughout the licensure process.
Understood.
Okay?
Fantastic. Thank you.
And I have to
Thank
say
you for your
that's
question.
all separate from the California PT Association, right? So all these entities, when you're new, they get confusing.
Gotcha. Thank you.
Thank you.
Appreciate it. Yeah.
Appreciate it. Okay.
Thank you. Any further public comment, questions? 2 empty seats here. Join us. Okay. Hearing none. Thank you, Valerie. So now, as I mentioned, we are moving agenda item 21 up to now, and this is the student Q&A. So the floor is yours.
So now it really is about the seats that are open up here. Just come on up.
Come on up.
If you have a question, there's 4 microphones up here. So if you want to, take turns, come up to each of the mics. So this is a kind of a new thing that we've been doing recently, where we want to have a little bit more access for applicants to be able to engage with the board and talk about kind of informational things. We we will say that this is probably the largest turnout we have, and half of you aren't even here yet. So thank you for that. I was not at the last board meeting at Sac State, but I did, watch it remotely. I just admitted to it a little bit. I did watch a YouTube recording archive of it. And I think it was really impressive to see the number of students then, and I was very proud of that. And this kind of makes that, we've never had this many people in this room for a board meeting that I can ever recall. So thank you all for being here.
Thank you for
And
having us.
Thank you for having us.
we're at your disposal. Ask away.
Sweet.
Go ahead. Yeah, go for it.
Go ahead.
Okay.
Try to bring the mic to you.
Good morning. My question was. Good on. Oh. Okay. Are there any trends in disciplinary actions involving PTAs that students should be aware of?
Well, please do.
This is, excuse me. This is one area that is universal for all of the healthcare boards. And it's really easy to follow, and all you have to do is take a lift home, and you're never going to have to worry about this. It's DUIs. People get DUIs, and especially repeat DUIs, and they're going to find their way in front of this board. They're going to spend thousands of dollars on rehabilitation programs. They're going to have their license on probation, which unfortunately has some difficult consequences in employment and finding work because of, I'll leave that to others. And truly, the idea behind discipline is, if someone is under the influence at work, that's going to immediately put you in probably a suspension. And the board has authority to go straight to a judge to have a licensee suspended. And the other risk is if someone has one DUI and the legal limit is 0.10 in California, is this correct?
0.08.
0.08. And let's say it's a 0.10 DUI. And they write a letter, they report it, they send a letter to your executive officer, and it says, I went to this Christmas party and they were serving this eggnog and it just didn't occur to me, and they're just over the limit. That might lead to a citation, and it depends on the circumstances. If they go out and are in an accident or a vehicular homicide, that's going to be a very different story. So, my goodness. So I will stop reading this parade of horribles to you and just tell you, take a lift. I can't imagine how many, I don't know if there's research on this, but I wonder how many deaths Lyft and Uber have prevented. Just because, if I'm gonna have one drink these days, or more than one drink, I Uber Lyft. I do not drive my car. I have 3 law licenses at stake as well. So,
To council's point, that kind of goes across all healthcare practitioners, all professional licensure for that matter. I think more specifically to your question though about specific to PTAs, what makes violations maybe different for you. One of the things that I would just advise you as a group when you become licensees is to understand the role of a physical therapy assistant and what that relationship to the physical therapist is in law. Regardless of what the physical therapist might ask you to do, because you are very close friends and there's been a very high level of trust established or what have you, you may have a physical therapist that might be contributing to your unlicensed practice of physical therapy outside of your scope. And when that happens, that's as much your responsibility as it is theirs, right? So be cognizant of where that relationship lies, know those limitations when it comes to supervision, and don't let your employers, those kind of financial decision-making structures ask you to do things that are outside the scope of your work. always serve as a physical therapy assistant. I understand the PT might think you're so much more capable of just being an assistant, but that's the only authority you have under the color of your license, right? And so if something bad happens and we come in from an investigatory perspective and we look at it, we're going to hold the PT accountable too. But if you as the assistant allowed the PT to essentially aid and abet you in the unlicensed practice of physical therapy, we're going to have to hold you accountable too. Does that make sense?
May I, Madam President? So another thing to think about here is in terms of crossing that line from practicing as a PTA into what is the practice of physical therapy that requires one to be licensed as a physical therapist. I can imagine an office environment where this would happen. You've been working with this physical therapist. You think they're great. They think you're great. They're training you. You're coming up to speed really fast. And one day they're going to lunch and a patient comes in and they say, hey, you got this, man. You can, or ma'am, you can do this with your eyes closed. I'm supposed to be here, but do you mind if I go get lunch? You say yes and work on the patient. I hope I'm getting those facts right. You committed unlicensed practice. And what I can tell you is this board is very conscientious of those situations, as well as the board's staff. If you find yourself in a position like that, this board is going to help you. Call in and complain. It also protects you on the employment side if you're retaliated against for calling the board.
I'd like to add, just as a note of caution, and this is to PTs and PTAs. I'm one of the public members on this board. If you're at a party and you have been drinking until 3 a.m. and you have to be at work at 6 a.m., you are still drunk. Just a note of caution. Just don't let that happen.
This is the subject that I'll probably talk about too much, so I'm going to just restrain, right? But I just want to make a couple of points of clarification. Council, had talked about the blood alcohol limit of 0.08 or higher, right? Just to be clear, in the state of California, driving while impaired is a crime in and of itself, regardless of what the BAC might be. The 0.08 or higher is an exacerbating charge. So the way I like to explain that in kind of layman terms that I can understand, is that we know people that are lightweights, right? That they have one or two, glasses of wine, and they might be at a 0.04 or 0.05, and they're still clearly impaired to operate a motor vehicle, right? So there's still a potential for a violation to occur there. We see offenses that come across through criminal history, and there's a continuum of DUIs, right? And what counsel was kind of describing, I would, for lack of a better term, describe as kind of the run-of-the-mill DUI, right? It's Friday night, you were at a club, you rode through a checkpoint, there was no officer observations of erratic driving, you didn't do anything to catch attention of law enforcement, you just rolled through a checkpoint. And in that checkpoint, maybe you are at 0.08, right on the threshold. Those are all the kind of things that we have to consider, whether or not that there's a nexus to practice to your licensure, right? Does that affect your ability to practice? Now, that's the kind of the left side of the continuum. Let's just change the variables a little bit, right? Now it's on your way to work in the morning and you're observed not being able to keep your vehicle between two lanes, and the officer, invokes a stop and brings you, to the shoulder, and there's observations of the smell of alcohol and slurred speech and blurry eyes, and they bring you out and you fail, sobriety tests, and you do a breathalyzer, and now you're at like 0.18. Obviously, that's a little bit farther to the right on the continuum than the first one, right? And you're on your way to work. What's going on there, right? Unfortunately for us, some of the cases that we see, the ones that I just described to you, are mild. We see BACs in the high, 0.2s, 0.3s even sometimes. And that starts to speak to substance abuse issues, right? If you're at a 0.28, a 0.33, and you were still able to operate a motor vehicle in any way, shape, or fashion, you probably have a very high tolerance, and it's probably speaking to a greater problem of substance abuse, right? If it involves an accident where there are injuries or people are hurt or you have children in the car, you know, all of those kind of things are exacerbating factors and are considered in that kind of nexus to practice conversation.
I'd like to say a few things. I'm thinking about kind of some of the cases that we've come across. They're not specific to PTA, but when I thought about it, since I'm one of the newer board members, I thought about the fact that it's probably not evident to us that, you know, the underlying theme here is professional responsibility. So whether it's, okay, I'm really not in a state to give my best and make sure that I'm ensuring safe, quality physical therapy, that's a judgment that if you make that, you are preserving your license and you're doing the right thing. And it's the same as if you had a big fight with your girlfriend or boyfriend and you show up and you're irritated and you're kind of belligerent, right? That can also get you in trouble. So we recognize that people have problems, that they make mistakes. And I think this board is very understanding of all of the factors that go into the reasons why people show up here. But the end of the story is, you know, is there something that you could do that could be a better decision in those moments where, you know, you could be putting your license on the line, right? So sometimes it means I'm going to call in today. I cannot do this today, or I'm not going to work with that person. I'm going to have to call and talk to a supervisor and say that person is utilizing me incorrectly, and it needs to stop, or else I can't, right? And those are again professional decisions. But since you are also licensed professionals, that is really important. The other thing that comes to mind too is, you know, the idea that no matter what, like he was mentioning, the council was mentioning, no matter what is happening, it's not always what's happening at the clinic. It's also what is happening to you outside the clinic that helps us understand if you're a safe individual making appropriate decisions to take care of a population of vulnerable people, right? And one of those things is if you get arrested for anything and don't report it to us, right? Because a lot of times the arrest is something that is not even going to be related to what's happening, or it was, you know, based on some other evidence and then it was thrown out, right? But it's the requirement that all professional licensees are reporting those so that we can evaluate to determine if it's something that rises to the level of concern for your ability to practice physical therapy. Yeah, I think that's it.
Really briefly, that is a very good point that Member Brandon makes. The requirement to report a crime within 15 days?
Within 30.
30 days, excuse me. At times, failure to report the crime is worse than the crime itself. Just report it right away. Report it the next day. Don't put yourself through sitting around, you know, agonizing about what you should do. You get a DUI, it's a .10 DUI, you know, just, or whatever happens, whatever you're required to report it. Because again, if you don't report it, and they're going to get a notification from the Department of Justice anyways. So they're going to find out if there's a conviction, and then you're going to be in the awkward position of it leaves at least the appearance that the licensee is trying to hide it from the board. And that's questionable in terms of their judgment. So they've just created a worse situation by not reporting.
And it could be like a bar fight. It could be like, you know, whatever it might have been, again, that you didn't mean to be in that situation and you got arrested. They thought that you were doing theft, whatever it might be. Making sure you're identifying that that's going to affect your actual profession.
I want to move to your question next, but I just want to add one little piece of that, and that is just for general understanding. When we are looking at an arrest or a conviction for you, whatever the outcome of that is not meant to be punitive to the licensee, right? That's not the mandate of the board. The mandate of the board is to protect the consumer in that situation. So any of the conditions that we might put on a licensee are not meant to be punitive. It's not punishment. It's building an order that creates protection for the consumer and still allows the licensee to work, right? And so sometimes there may be some conditions we might ask you to do more education, restrict certain modalities or certain forms of supervision or those kind of things for a period of time. But that is designed to allow you to continue to work and still put insurances in place to protect the public, not to punish you as an individual. So.
Understood.
I'm going to add one last thing, and then we'll move on to you. But I just want to give you my personal, the top 3 offenses that I personally have looked at. The number 1, DUI. Number 2, record keeping. And number 3 was domestic violence cases. So just those were the top 3. Okay, now.
Considering the PTA scope of practice, I was actually wondering if there's any projects happening to expand on the PTA scope of practice at all.
That's a good question for you.
Making you work today.
What she means by that, the reason it's a good question for us is kind of speaks to the separation between the Physical Therapy Board of California and the California Physical Therapy Association, right?
Right.
So because we are an advocate for the consumer, anything that we would see as an expansion of scope would have to be from the necessity of consumer protection, right?
Understood.
And a good way to look at it is if it's good for the profession, those kind of campaigns should be driven by the professional association.
Gotcha.
If it's good for the consumer, it should be driven by this board.
That makes sense.
If it happens to be good for both, it should be done by the association.
Gotcha.
And the reason I say that is not that like we're trying to get out of work. It's just we can't be seen as advocating for you as licensees, right? This isn't a protectionist board. We're not here to protect licensees. We're not here to advocate for the profession itself. Essentially, and it sounds callous, we're here to police this profession and make sure that it's safe for the public.
That makes sense.
Really, really briefly, at times we don't think of it this way because when we say lobbying, we think about Congress or the president or the California legislature. But, and this is no disrespect, this board works very well with their association, but when they are here, they are lobbying. This is a government agency. So it's something to keep in mind. But, you know, this board does a good job of not making an adversarial relationship. And as Mr. Kaiser mentioned, when they are presenting something that we think actually enhances consumer protection, then as they move forward, the bill will come before the board and the board has the opportunity to support it, which generally the board would if it's something the board thinks is enhancing consumer protection. No, it always would if that's the case. Sometimes it's not always clear
Right.
whether that's the case or not.
Okay.
So, but to answer your question more specifically, the California Physical Therapy Association right now is looking at proposing legislation in the next session that they call the Modernization of the Physical Therapy Practice Act.
Oh.
And so there's quite a bit of proposed changes there. But again, those are things that are being proposed by the association. They're the right person to get that information from.
That
And to
makes sense.
council's point, once that legislation is actually proposed, meaning that they seek an author and the author proposes it in one of the two houses, we would then look at that bill, determine if there are any kind of consumer concerns or impacts in that proposed change of law. And then the board may, choose to kind of opine. And to council's point, we might support it if we think that it's consumer based, and we might oppose it, right? And we do get along with the association really well. If we got along with the association really well 100% of the time, one of us is probably not doing our jobs.
That makes sense.
Can I say at the end of that, if it were to pass, if there were to make changes, then we would be responsible for if there was a change in how we implement our regulation of the practice, right? It's a trickle down, and then we have to respond and make sure that our expectations are matching what is new in the law.
That makes sense.
I would encourage you to just keep your ears open, everybody, regarding your scope. And if you receive materials for future meetings that say this is an agenda item, we want your participation. We want to hear from you. So come and, come up to the mic and make your comments and make your case.
Yeah. Shameless plug. When we get to that stage where legislation is actually signed by the governor and goes into effect, it can be kind of like a high conceptual level. And then the board is tasked with promulgating regulations from that authority. And in that process, it's a very public-facing, public-oriented, public participation process. There's a lot of you in this room today, right? And we're happy about that. When we've had regulatory hearings in the past, meaning that this board's proposing regulatory change, and there's only 3 or 4 people in the audience, they're not really participating, right? We're not getting a lot of feedback, that kind of thing. So we want to encourage that participation. But we want those perspectives. We want those ideas, even those concerns, right? Like, I don't like this law. It's stupid. Okay, well, let's talk about it.
Right.
I'd rather talk about it in that designed period than put that regulation to effect and then have everybody complain about it when they didn't participate in the process in the first place.
Makes sense.
And just to finish the loop really quickly, that is the role of the association to tell its members what's going on and have them support or not support as they see fit.
Just, add a little bit to that is that although we're a consumer protection agency, we do have sort of a cross puzzle portion of it with the association. Obviously, we're part of the industry. As part of the healthcare industry, the direction is integrated care. So as for information purposes, as integrated care progresses, physical therapy is going to be integrating a lot of its services with other physical healthcare or even mental health care, right? So as that evolves, that's where this communication and your involvement is essential, because that will give us information also to evaluate.
Absolutely. Thank you.
I think the reason, Mr. Kaiser, one of the reasons Mr. Kaiser said we're happy to see you, we don't usually get as much attendance, but there's still, even among licensees who've been licensed for many years, who are confused about the difference between the PTBC and the CPTA. So you are going to be a better informed licensee, and you will be in a position to actually point out the difference. So don't be surprised. I wouldn't be surprised if you did that at some point, and maybe even more than once.
All right. Hello. Switching gears here, this may be a better question for the association, but is there a future for having prior coursework from a PTA program credited towards a DPT program? If there's talk about that, I'm not sure.
It is a better question for the association, and even for the National Association at that level. There has been talks about bridge programs, and I know that there are some experimental bridge programs in other states. Keep in mind that every state is its own jurisdiction. And I'll give you a good example of this, right? So in California, we have an equivalency program for PTAs, right? Meaning that maybe you got your training in the military or self-study, or you got a bachelor's in kinesiology, or those kind of things. There's actually a pathway to becoming a PTA using those methods. Having said that, that pathway doesn't exist in other states.
Gotcha.
And so while you might use that pathway to get into the into a PTA license in California, it may not be accepted in those other states. So using your PTA education and background to go towards your doctorate level PT license in the future, it's up in the air.
Gotcha.
Yeah, I would say from a DPT program that the courses, let's take for instance anatomy or some of the foundational science courses in a physical therapist program is taught at a doctoral level. So it's much more detailed, and that would serve you well as a physical therapist. Yeah.
Thank you.
Yeah, good question.
All right. I'm curious, as a PTA, how can I defend myself if I'm accused of violation or misconduct?
Can you repeat the question, please?
As a PTA, how can I defend myself if I was accused of violation or misconduct? They're in practice.
Falsely accused?
Yes.
But, I don't know to what extent, this is a question for the professional licensees. It's a pretty strong practice now to, when there's physicians performing intimate exams, that you have a chaperone. And I don't know to what extent, to the extent that there is an aide in the room, if there's a concern about that, I would call an aide in the room. That's what I would do.
I'm not sure if you're only talking about being accused of inappropriate touching, or you're talking about in general?
In general, yes.
Yeah, well, no, it's okay.
Yeah.
You're right. You got on track there.
Unfortunately, honestly, this board, it came up earlier, so I'll go there. But this board, being a profession where there's a lot of patient to therapist contact, which I experienced over the last 2 months getting physical therapy. This board has, in my view, and this is arbitrary or to some extent, a very low number of sexual assault cases compared to some other boards that have similar patient licensee contact. So the other side of that coin is your board also has a very, very strong statute, not a regulation, a statute. If it's proven that a physical therapist sexually assaulted a patient, their license is required to be revoked. There's no ifs, ands, or buts about it. It's done.
I think speaking more generally, one is I would tell you, if you're contacted by this board because a complaint was filed against you, take a deep breath. Don't panic, right? We open each and every complaint that we receive and we investigate it until the fact pattern bears otherwise, right? We're not looking for your side of the story or their side of the story. We're looking for the truth. And we might take everybody's perspectives to try and put that together. Having said that, document properly, be supervised properly, do everything right, and do it with the right interests at heart, right? You're administering care for medical necessity, not for financial gain. These are all kind of some basic things. But understand that, while there are about 40,000 of you between PTs and PTAs, we only get about 500 to 600 complaints a year. And we only take disciplinary action on about 50 to 60 a year, right? The number's quite minuscule when you think about it, right? Mm-hmm. When we talk about 600 complaints and only 60 disciplinary actions, the part that you have to kind of divide that up even further is that some of those complaints we receive are actually hits on your criminal record, right? That you had some kind of altercation with law enforcement, a DUI, something along those lines. So that's a portion. The other portion is we get any other complaint you can quite possibly imagine, right? I went to my physical therapy 45 minutes late and they wouldn't see me.
Sorry. Yeah.
Oh, okay. So we open that complaint, we investigate it, we find no fault, no jurisdictional violation, and we close that complaint, right? And so imagine of all those 600 complaints, how many are personality conflicts, how many are misunderstandings between practitioner and patient that don't really rise to the violation of the Practice Act, and those are closed, right? So cooperate. That's the other part, right?
And don't panic.
Yes.
Because you may get a letter from the board and your heart's gonna, your blood pressure's gonna go. Just remember that it may be that exact case, the 45-minute late case, but the board has a duty to contact you and ask for your information. And hopefully that is all it ever is. And I can relate to this situation. I used to be a public defender, and people filed complaints about us all the time.
Yeah. And just so that it doesn't complicate the matter further, and counsel kind of touched on it earlier about, should you be arrested or should you have a conviction, you have that 30-day window to report it to us, right? And if you don't, then you've added a new condition for us to consider as to why wasn't it reported timely? If this board receives a complaint about you and we reach out to you, right, to do an interview, to get your side of the story, cooperate with that. Don't try to delay it. The more that you kind of put it off or that kind of thing, that now becomes a consideration in the case, and it has a weight in evidence also, right? Failing to cooperate with the board investigation is in and of itself a violation, right? So it's not the end of the world, right? And after all, as you can see by this panel, right, we're all reasonable people. We're just trying to figure out what actually occurred.
So one other thing that us as professional members keep in mind is informed consent, and not only documented but processed through and look at your patient and determine, did they understand what I said? Do they know why I'm doing this? I mean, there have been times as a professional that I said, oh gosh, I don't have the buy-in here. The light bulb's not going off, and you're touching the patient, you're moving them. Those are the ones that are very highly likely to come back and say that person hurt me, And it didn't mean, obviously, they didn't understand that the maneuver or the treatment you were going to do had a potential for making them more sore. But that's part of a true and thorough informed consent, and that they could say stop at any time, right? The other thing that the council brought up that was pretty significant, because I'm in pelvic health, and that is intimate exams, or just it really is the appearance of impropriety that gets people in trouble too. So if you are in the office or in a space that is a closed place by yourself and you feel uncomfortable, also, right, recognize how that patient might feel if something maybe they also might be a little more vulnerable. They had a history of a sexual assault or domestic violence, right? So if at all possible, make sure that all of the appearance of impropriety is minimized by witnesses, and any time that you can be in a more open environment without compromising their modesty, consider that. And you can always ask for an aide to come and assist or be present.
Yeah, Dr. Brennan is giving you probably the best piece of advice I could give you, and that's practice informed consent, right? A more educated patient is a less likely patient to misunderstand or misconstrue very sensitive modalities and consider the worst, right? You may not know what kind of trauma that patient's experienced in the past and what, those kind of things might be perceived by them. So here's what I'm going to do. Here's why I'm going to do it. Is that okay? Frequent check-ins, the more sensitive the treatment, the more, frequent you do informed consent, so that's a really good piece of advice.
I have an example, and I consulted with Madam President here, who thinks it's a good idea to go through this a little bit. And I can discuss this because it is in a written decision, and the name is escaping me right now, but this is a decision of another board that relates to an intimate exam. And to me, it seemed very clear that this is what occurred. There was no intention to sexually assault the woman. The licensee was just way too gung-ho about getting this examination done. And the woman was from another culture, spoke another language, and I don't know if it was a communication barrier, but there wasn't that kind of discussion. We're going to need to do this. We're going to need to do this. Are you comfortable with this? It was, let's just start this. And there was a really bad reaction. There was sexual assault. There were charges filed. I mean, it was, if my memory is correct, I may be putting two cases together, but all could have been avoided.
Mm-hmm. Yeah, I remember either that case or something very similar that we saw, and the licensee was like, "What'd I do?" Right? Because he was providing treatment, but there wasn't that discussion, especially as he moved into more sensitive areas. I think so.
I'm sure. Wrong board. It was your board's case. I'll find it. I'll ask.
Sure.
I'll get it to you somehow, if you'd like to read it.
The four of you have any further, or do we want to rotate you out?
We can, if anybody else has any more questions,
Well,
we can.
before we do that, can we take 10 minutes?
Absolutely.
And then your next group of questions can
Yeah.
be prepared and we can keep this party moving.
Thank you, guys.
All right.
Yeah.
Thank you.
Thank you.
Everyone. Of course. Wow, that was a great Q&A session. Thank you guys so much for your questions. I actually learned some things because of your questions, so thank you for that. What we're going to do now is we are going to go back to our agenda, and we're going to do agenda items 19 and 20. We'll break for lunch, and then after lunch, we'll open up the Q&A again at 1 o'clock. Okay, everyone? So moving on to agenda item number 19, Consumer Protection Services update. Hey, Carol.
Good morning, everybody. My name is Carol Phelps. I'm the manager of the Consumer Protection Services unit here at the board. And I'm going to present the quarterly update for our unit. First, foremost, I'd like to welcome Jim Heaton to the board family. Jim joined us in November as an enforcement analyst. Prior to joining the board, Jim was an annuity and long-term care brokerage manager for many years. And in that role is very familiar with laws, regulations, and government agency policies affecting the insurance brokerage industry in multiple states. So with this background, he is quickly acclimating and has already taken on a caseload of consumer complaints. He's relieved much of the other analysts' excess of cases, which everybody's very happy about. We're more in line with kind of what the expected full caseload is for each analyst, and they're kind of able to breathe and get their head above water now. So they're very happy about that. And the CPS unit is fully staffed now. We have no vacancies in CPS. For now, so
Very quickly before you continue,
Yeah.
while you may be fully staffed, it might also be time to reassess whether those staffing levels are appropriate. And so we might be looking into the next year's session and looking at budget change proposals, just doing a workflow analysis to determine whether additional analysts or probation monitor are required for the CPS unit.
Correct. All our currently authorized positions are filled. So in the first quarter, as has been previously mentioned, the board held 2 major trainings, the first of which was for Division of Investigation. Attendees included the DFI investigators and supervisors, as well as board enforcement staff. And the training covered specific aspects of investigating complaints for the board, including the board's inspection authority, how to interview witnesses and subjects, proper document collection for evidentiary purposes, among other topics. Deputy Attorney General John Gatchett provided this training on behalf of the board. Staff also coordinated a training for our physical therapist expert consultant program. In addition to 11 new experts who attended the training, 14 current experts also attended to refresh their knowledge and understanding of the program requirements, and the board enforcement staff attended as well. And Deputy Attorney General John Gatchett also provided this training for the board. The CPS unit has held one-on-one telephone conversations with each new expert for the purpose of summarizing the program expectations and to answer any questions that have come up since attending the training. So we are also providing timely feedback to all of our experts as needed on a case-by-case basis. So, when a report comes in, if there are any minor issues that maybe just need a reminder about the expectations and requirements, or just kind of anything where we feel like this expert may need a little one-on-one conversation and reminder or coaching. We have those as we're able to, and as those cases come in, kind of in the hopes of improving that expert's work product for us so that we can continue to use them for future cases. We also encourage each expert to contact either myself or the assigned analyst anytime they have questions. We're very open with speaking with our experts at any time. As you've already heard, plans are already underway for our next investigator training in 2025, as well as plans to continue to conduct the expert consultant training on at least an annual basis with both in-person and virtual options. In September and October, 2 of our enforcement analysts attended and completed the National Certified Investigator and Inspector Basic Training course, which is provided by the Council on Licensure, Enforcement, and Regulation, which is CLEAR. The course provides a great overview of complaint investigation law, procedures, techniques, and considerations. I think with the exception of our newest analyst, all of our analysts have now completed this training. The board, in coordination with DCA, recently issued a press release regarding a complaint investigation that resulted in the revocation of the licensee's physical therapist assistant license. This was the press release that's on our back table there, and DFI also mentioned it in their presentation as well. Based on the evidence obtained, just a little bit more about that case. Based on the evidence obtained through DFI's investigation of the complaint, the case was forwarded to the local DA's office, which resulted in a criminal conviction and the former licensee being required to register as a sex offender. The press release is, like I said, available on the back table here and also on DCA's press release page, which you can link to from our page. If you go to the publications tab, there's a link in there for the press release page. Now, a little bit about our statistics. If attachment A to this report was our quarterly statistics for quarter one. Performance measure 1 measures complaint intake. We received a total of 158 cases this quarter, including 103 consumer complaints and 56 reports of arrest or conviction. Performance measure 3 shows an average case age in days for all cases that did not result in a referral to the Attorney General's office for formal discipline. The average case age was 168 days, which is 38% higher compared to last fiscal year, but these numbers are known to fluctuate greatly as they reflect the average of all cases and encompass the entire investigative procedure that involves the timelines, workloads, response times for multiple parties. Our target for this performance measure is 180 days, so with that 168-day average, we are meeting this target. Performance measure 4 captures the average case age in days for cases that were referred to the Attorney General's office for formal discipline. 10 cases were finalized at the AG's office this quarter, and they took an average of 632 days from receipt of complaint to final outcome. The target for this performance measure is 540 days, so we are not meeting this target at this time, but 10 cases is a small number of cases to get an average for, so even 1 or 2 cases can push that over the edge. So in summary, in quarter one, we initiated 158 new cases, issued 8 citations, completed 122 desk investigations, referred 14 cases to the Attorney General's office, received 1 interim suspension order and 1 PC-23 order, and closed 10 cases after referral to the AG's office. Our current caseload consists of 417 cases among our 6 analysts. So attachment.
Can you repeat that?
The current caseload, 417 cases, kind of divided between our 6 analysts that we have. And attachment B is our disciplinary summary, which shows 2 public letters of reprimand and 2 public approvals, which are similar documents. A public letter of reprimand is our internal document that Jason authorizes and signs, and the public approvals are they go through the accusation and discipline process to get those. 3 licensees were placed on probation. 1 licensee surrendered their license by stipulation, and 2 licenses were revoked. All of our disciplinary actions are available on the DCA license lookup. That concludes my report. I'm happy to answer any questions.
Carol, what's a PC-23 order?
So that's Penal Code 23, and that's an order issued by a judge in a criminal proceeding, ordering the licensee to basically cease practicing during the pendency of the criminal matter.
Thank you. And is there a target number of experts that the board looks for, or do we look at all the applications and say, yeah, this is someone in a certain area who works in a certain setting that would be beneficial?
I'm not sure that we have a target number, but we look geographic area where there's need. If we have no experts or a small number of experts, and we also look at practice area. So if there's a specific practice area that needs a specialty like public health, that we need to have an expert in that area review a case, we look for those kinds of things when we look at the applications that come in.
Thank you.
The only other element that I would probably add to kind of the evaluation of the number of experts, aside from specialty or geographic, is performance. Their ability to participate. It can be a lot of work, right? And so sometimes experts sign up to become an expert and realize after their first experience that this was maybe more work than they might have anticipated. Also, the training can be daunting, right? We try to send them or buddy them up with a veteran expert for their first couple of attempts. Geographic travel can be a deterrent for some people to participate, especially in those kind of remote areas that we don't have a lot of experts for. So no sweet spot, if you will, for numbers. There's a lot of different factors that we have to consider.
Do you mind, because of the opportunity we have for the public to go, there's the process, the options for disciplinary. We have like public reprimand. Could you go through them just briefly? I know they're in our glossary. I don't know if everyone has access to that. Make sure you get one of those.
It is part of the attachment B to the materials for this item. But yeah, so like Jason said too, like consider that we have, over 500 cases received in a year. And of that number, it's a very small number of cases that end up getting either a citation or disciplinary action. But the kind of the range of actions are, either A, we close the case because there's no violation, or a very, very minor violation that doesn't warrant action. It could warrant like an education letter where we'll remind the licensee of whatever the area of concern is, and that to be aware of what the law is related to that. And that's not a public action. That's not a disciplinary action. It's just kind of a memo to the licensee. The public action starts with a citation, which is, it's not a disciplinary action, but it is a public record for 5 years on the licensee's record. A citation often comes with a fine, kind of commensurate with whatever the violation is. And the fine could range anywhere from $100 to $5,000, depending on the severity of the violation. If it rises above a citation, the first option above that is an in-house public letter of reprimand, which our EO has the authority to issue those in lieu of proceeding with an accusation, in the public administrative hearing. If the licensee agrees, we issue that in-house public letter of reprimand to them, and that is a disciplinary action. It's a public document, permanent on their record, and it can also come with cost recovery and potentially education courses related to whatever the violation was. Right above that is a public reproval, which is a similar action to the public letter of reprimand, but it comes after an accusation has been filed. So that will go to the AG's office. The accusation is filed. That's a public document that lays out what the charges are, what our code sections are that relate to that under our jurisdiction. And then a public approval is often either stipulated to, or, if it goes to a hearing, a judge orders a public approval for something that is a discipline worthy, but doesn't warrant probation or, suspension or revocation or anything like that. And then above that, you have the probationary licenses. We put a licensee on probation for a certain term where they have conditions that they have to adhere to during that term. There's a lot of conditions covered, and we have those all in our disciplinary guidelines if anybody would like to peruse what those may be. But it just is case by case what terms are included in any probationary order. Above that is either license surrender by disciplinary action. It's a stipulated disciplinary surrender, or a license could be revoked. And those obviously mean the same thing in the end. They lose their ability to practice.
Thank you.
Of course.
Any further questions from board members? Any public comment for Carol? Hearing none. Thank you, Carol.
Thank you.
We will move on to agenda item number 20, probation monitoring services update. Hi, Monty.
Hi, Monty.
Morning, board members.
Good morning.
Name is Monty Martin. I'm the probation monitor for the board, and I am reporting on the first quarter of the 24-25 fiscal year. During the first quarter of the year, there was a high of 71 licensees on probation at one time or another for various causes. Besides the 50 licensees on probation and actively working in the state of California, there were an additional 7 out-of-state probationers tolling or not receiving credit toward completion of probation because they are out of the state, and 14 in-state probationers tolling due to unemployment or underemployment. 3 licensees were placed on probation in the quarter, and 4 licensees completed probation. 1 person was revoked for non-compliance. Of the 50 licensees that are not tolling, 9 are enrolled and participating in the board's substance abuse rehabilitation program, equaling about 18% of all the licensees on probation that aren't tolling. 2 licensees enrolled in the program and 1 licensee completed the program in the quarter. There were 8 instances of non-compliance with probation. Most instances of non-compliance were minor violations for not being available for quarterly interviews or not submitting required paperwork on time. Then you have the attachment of the statistics behind the report there. That's basically it. Any questions?
I can't tell. Thank you, Moni. I do have a couple of questions. So about 50 on probation, not tolling, 9 in Maximus. So does that mean the rest have some sort of restrictions? They're on probation and...
Yeah, so for the 9, they have restrictions that have to do with substance abuse. The other ones are on probation for non-substance abuse related causes.
Thank you. Okay. And the minor non-compliance issues, are those something just for you to note, or I guess I'm trying to see what the gravity of something like that is.
I'm just giving you the information. Most of those non-compliances are coming from people out of state. So there was a time when we weren't requiring people that were out of state to keep in touch with us and notify us about what they were doing. We've changed that and have required, even if you're out of state, you're still required to send quarterly reports of compliance and check in with me quarterly for interviews. A lot of those people are non-responsive. They're gone. They don't want to come back to the state. So they're kind of ghosting me. So they can only do that for so long before we take discipline if they don't comply with the probation terms. So
And that's what closes the loop.
that will close the loop. They'll either get on board
Mm-hmm.
or they can choose to surrender the license if they don't. Or if they don't do anything, then we may have to revoke their license.
Thank you.
Moni, I just want to thank you for your diligence with documentation, and I want to commend our entire unit for, really upholding opportunities for people. Some of the cases that have come across, I was like, how much opportunity people have to continue to practice, and just having an appreciation for, giving the licensee, being human. Like, yes, it's human. You might not make an appointment, writing it down. Let's make another appointment. Let's make another, schedule in the process to get your information and all of your requirements completed. So I'm just really incredibly proud of how we've structured that and that we uphold that, so that we really want people to be able to practice if they are safe and competent and follow through.
Minor violations in and of itself doesn't have to be a big issue, but multiple minor violations can lead to something more major.
And I think what struck me was that it's almost as if we're waiting for the licensee to say, okay, no, I'm not going to be able to do this. I'm not interested in continuing. Like you said, they're individually surrendering, not that we weren't giving them opportunities to make it through this process.
in some instances, that really is the case, right? So when we're talking about some of those probationers that are outside of the state and tolling, it's kind of reasonable to expect that they don't plan on returning to the state of California. They, may have given up on practicing as a licensee in our state. Okay, but we are sitting here waiting in case they change their mind. And that can only happen for so long until they become kind of an administrative burden and the statistics that we would be reporting don't actually reflect the reality, right? And so in an effort to kind of true up the books, if you will, we still need to know status reports for them on a quarterly basis. And that status report might just be, I'm tolling. Yes, I know that you guys are still interested in me, but I'm still not coming back to California. Okay. If they adhere to that, then they are in compliance with their probationary order. They still are an administrative statistic. If they ignore money altogether, we can only allow that for a certain amount of time, and then we have to give them alternatives, options. Okay, if that's the case, if you're not coming back to California, you can initiate a surrender in a cause in your own disciplinary order. It's up to you as the licensee. It's up to us to accept it or approve it, but it's their option, right? If they still don't answer to Monty, nope, I'm not filling anything out. I'm not doing anything for you. You guys can go kick rocks. I live in Montana in a cave and it's not happening. All right. Well, then we're going to have to petition for revocation based on these violations of the probation order, if you will. It's a lot of expenditure, but you still got to consider what the administrative load is over time. And so, like, in this case, we really do want to split the statistics out so the board can see the practical application of the probation program.
Any further questions or comments for Monty from the board? Any public comment? Questions?
If you ever been curious what happens after you get in trouble.
Hello. I push this button.
Yes.
Okay.
So my question is, my name's Michaela, and I'm at Union College. I might be really good that like you guys already know the answer, but for us students, so when that happens, is it just your California license that's taken away, or is it the whole entire license of both of them?
So I think that's a great question, right? The answer is kind of two-pronged. One is we only have the jurisdiction of you as a licensee, and the license is a property right. It's really your privilege to practice that art and science in this state, within the state of California. We can only restrict that. Having said that, the states do talk amongst themselves. There are information networks, right? So let's just say you hold licensure in multiple states, and each state has its own individual practice act. If you get in trouble, and we'll just use a hypothetical, you reside in Texas and something happened in Texas, that adverse action, that administrative action that Texas took against the Texas license is going to be reported to the other states for the states to consider whether or not that's something that should be actionable in that state. And we really have to look at the differences too, right? It could be, maybe in Texas, the licensee failed a continuing competency audit. But looking into the detail of that order from Texas, it necessarily might not be a violation in California.
Okay.
So we may choose not to take action, or we might say, to the letter of the law, you still did not pass an audit that occurred in Texas, and that's an issue for us in California, and we might echo that order. So it can have an effect, but it is not automatic. It has to be done on a state-by-state, jurisdiction-by-jurisdiction basis.
Just to piggyback on that, I had a probationer leave California for Arizona, and he doesn't want to come back to the state. So I've asked him, do you want to surrender your license? And he's hesitating to give me an answer because he's afraid that if he surrenders his license here, it will have adverse action on him in Arizona. So he's gotten himself legal counsel to see what kind of impact that may have on him if he does surrender his license here in Arizona.
Okay, got
But,
it.
but to put that even in further context, the reality of the matter is Arizona is aware that he's on probation in California. So is the surrender worse than the existing probation? That'll be up for Arizona to decide in what they do with him in Arizona.
Okay, that makes sense. Thank you.
Thank you.
So we will take this first. Thank you guys. Thank you guys so much for showing up today. It's like, I was so excited when I walked in the room, like, whoa, we got company. So thank you so much for your question. Board members, anything you want to say to our visitors today?
Tech's gonna be meeting soon. Thank you all for your engagement today. We hope to see you again and good luck. And then we'll look forward to seeing IoT after lunch.
We'd love to see you again in this capacity. So, thank you guys. So we are going to break for lunch.
Just a shameless plug real quick before we do. There was a question that was asked of me during the break about, just attending board meetings. And I think what I really wanted to emphasize is that the purpose of the board meeting is for the board to present to the public, right? So you're always welcome to attend meetings as any form of stakeholder, as a consumer of physical therapy services, as a consumer of professional licensure services, what have you, as an applicant, as a licensee. And we even went one step further, right? We said, as a licensee, once you become a licensee with this profession, we want you to engage in this process so much that we will give you continuing competency credit for attending board meetings, right? 2 hours a meeting, up to 8 hours for your renewal period, right? And so that's just to get you to come, attend, and engage. So thank you for being here.
So it is 11:33. We are going to break for lunch and we will return at 1 o'clock and open up the Q&A for the next group. So thank you guys. Our meeting is called back to order at 1:10. Thank you guys so much for participating in that wonderful photo practice. And we are going to pick up on our agenda with the student Q&A. So if you guys notice, we have 4 chairs here, and we're asking that if you have questions, please fill up all of the chairs, and then once that group is done, we'll bring in the next 4, and then the next 4, and so forth. So, are you ready?
Who wants to volunteer?
Who's first? Let's go.
So before you ask your question, just try to introduce yourself, what program you're from, and then fire away. And we'll try to answer your questions to the best of our ability.
All right, you'll start. Hello, all. Armando Mendoza, Institute of Technology, student physical therapist assistant. Yes, please.
My name is Robert Garcia. I'm a student physical therapist assistant at the Institute of Technology.
Jose Ramirez, Jose Ramirez, SPTA, Institute of Technology.
Nicole Russell, physical therapist assistant student at Sac City College.
Perfect. So firstly, I'd like to express our gratitude to the board for allowing myself and our colleagues to attend and represent our fellow programs at today's meeting. We highly appreciate it. And then secondly, to start off with the question, given the integral role PTAs play in patient care, should the board consider amending the Practice Act to include PTA DCA representation, ensuring their perspective contributes to decisions on regulations and patient care policies? If needed, I can repeat.
Oh, you're going to defer to me first? All right. Well, I'll start with the technical side of it, right? So that kind of change would require legislative change. And those are usually going to be introduced by an author in the legislature, either on the Senate, the Assembly side. if this board were to ever introduce legislation for that, it would be solely from the perspective of consumer protection and whether there was a necessity for that. The idea of a PTA serving on the board, it's not unusual. You find it in other jurisdictions, but in California, for it to be driven from the consumer perspective is it's probably not likely, right? It might be something that comes from the CPTA or the California Physical Therapy Association and an advancement of the profession. It's not that we discount the contribution that PTAs make to the healthcare, but when it comes to the decision making about laws and regulations, it is an assistive personnel license to the physical therapist. And similar to kind of the Practice Act, all the care that you provide as PTAs is the responsibility of your supervising physical therapist. There are roles to kind of respect in that situation, and one of those parts is there ever going to be a conflict of interest where a physical therapist assistant might have an unjust point of leverage over the superior license of a physical therapist? You can kind of see the spirit of where that lies in the PT Practice Act today. Sometimes you'll find that PTAs can serve as like a director of rehab in a clinical facility, right? That's not uncommon, it happens. In that situation, when it does happen, the PT Practice Act explicitly states that PTA can't serve in both roles. They have to do one or the other, right? If they're serving as the director of rehab, they can do that as a lay person. They might have influence on the hiring and the firing of physical therapists. But if they also serve as a physical therapy assistant in that same clinical facility, that could create a conflict of interest where that subservient license now has a superior position over the physical therapist license. So it sounds like a no-brainer, right? Like more contribution is better, but there's a couple more perspectives to look at. Is there anything else?
Appreciate the question. I think it's a good question, and thanks for answering it, Jason.
I want to mention, in my experience this year being an alternative delegate at the FSBPT, I do believe other states have had PTAs on their board. I think also there are so many different places where your voice is incredibly valuable and serves to inform about your role in healthcare service delivery and also the team approach for the type of care we provide. So certainly this isn't the only place that can be impacted by your voice. And like I said, I think that there'll probably still be conversations about that in the future.
One thing that I'd add to that is just a reminder based on what Dr. Brannon just said is, and we kind of touched on it earlier this morning about the regulatory process in how regulation governs the practice and how we want that promulgation of regulation process to be very stakeholder oriented. We want both consumers and applicants and students and licensees, both PT and PTA, involved in how the regulations are written. We want that input as part of the process. There's a huge point of contribution for you there, right? When the legislature hands us a new statute and says, here's a law that needs to be implemented in your practice, it's usually a very high level conceptual idea. A good example would be like the board shall have a continuing education program. Okay, but what are the working parts of that continuing education program? How does it work? We want all the stakeholders that are affected by that statute and any regulations that come subsequent to that to have input into that, to troubleshoot it, to tell us what they think, be involved in that process so that the PTA perspective would be considered at that point. If it's a consideration of change of regulation for assistive personnel rules of any kind, whether it's supervision or documentation or anything like that, you have an opportunity to have a voice in that process.
Perfect. Thank you.
Hi. Once again, my name is Robert Garcia. I'm a student physical therapist assistant at the Institute of Technology. Going off of what you had mentioned earlier with the budgets, and you had mentioned that the renewals and the application fees contribute to the budget. Mm-hmm. Just following off of that, I did have a question regarding the renewal fees for both the PTs and PTAs. They're both the same, around $300. Mm-hmm. I was just wondering why is that the same for both PTs and PTAs, considering certain factors such as educational differences as well as financial and annual salary discrepancies. So why are those? Why is it the same for both? And then is there any way that these memberships can be lowered?
I'm going to dissect it into 3 different parts. One, I see the knuckle. Right? First, I would say is the perspective of whether or not a certain profession's ability to garner a certain wage should have any kind of influence on what the regulatory fees are is a constant discussion across all of professional licensure, right? And it's definitely part of that equation. The simpler explanation, especially when it comes to like applications, the applicant fee is actually calculated based on the amount of labor that's put into processing the application itself. For PTs and PTAs, you all have exactly the same application process, right? For us, on our side of it, the ministerial side of it, the admin side of it, you still take a national exam, you still do the jurisprudence exam, we still do a criminal-based background check, we still need a passport photo, we process the application in the same way, in the same fashion, hence the application fees come out the same in assessment. The renewal fee is a little bit different. The renewal fee is the ongoing contribution to the board itself. And so when you said that it contributes to where we get our money, it's actually the only place we get our money from, right? No taxpayer money at all, right? The only other source of revenue that we have is what we call cost recovery. So like for those bad actors that get put on probation or something like that, we have the ability to charge them for the prosecutorial costs of that case, which if you think about it as individual licensees, that makes sense, right? If I didn't charge them, who would I charge? I'd charge the rest of you in that renewal fee, right? So accounting wise, it makes more sense. If they had the bad behavior, they should pay for their portion of that bad behavior, at least to a certain extent. The rest of it that can't be covered in that cost recovery then comes out of the renewal fees. The administrative side of the renewal fee is also very similar in how we collect costs. We conduct investigations against complaints with PTs and complaints with PTAs, and we do it in exactly the same fashion. We had a presentation this morning from the Division of Investigation. We hire expert consultants to opine and provide opinions about the standard of care, and all those things are the same for both PT and PTA. So that idea of, but PTAs can't make as much money as a PT, where it's a contributing factor, it's not a deciding factor.
Yeah, like I said, you had already partially answered that, but
Sure.
I appreciate the clarification.
Now, your last question was, can we reduce those fees? So, I think I said this either yesterday or today. As the administrator of the program, one of the things that's like on my bucket list before I retire is I will eliminate a fee or reduce a fee before I retire. Right? It's an aspirational goal in government. You don't really ever hear about fees going down charged by a government agency. It's just something we can't do. But we would try. You also heard in that in the papers that you have in front of you that right now we have a fund condition of about 8 months in reserve. Meaning if we stop collecting revenue today, we could function for about 8 months. If we ever get down below 3 months, that's usually a time to consider a fee increase, right? Because we're still dividing it amongst the licensing population. The trigger that says you should reduce fees isn't quite so forgiving for you guys, right? Yeah. If my fund condition gets to about 24 months is when we start considering a fee reduction. And I only have 8 months, so. But, it's when it's appropriate, we would do it.
Perfect. Thank you.
Good. All right. Any more answers to his question, board member?
Yeah, you guys want to reduce fees?
So as Armando mentioned, we appreciate you guys having us, especially with the large size that we brought in with 3 schools. But thank you again. So essentially my question is going to go based off of something we'll probably talk about according to the agenda here in the future with statute AB 3127. So for anybody not familiar with it, essentially it's eliminating the mandatory, what is it, like sorry, I lost my train of thought here. It's eliminating the mandatory report for abuse for adults, excluding children and elderly. So the question is, how does the board plan to support healthcare professionals in implementing the changes proposed in Statute AB 3127, especially regarding training on patient-centered counseling and navigating the new reporting protocols, if this does get passed?
So I'm going to let counsel. I'm tempted, but I also see him in the corner of my eye. Go ahead, Mike.
I mean, there could be a something you'd like to discuss with the board here, but that bill failed, so that bill is not law.
Oh, yeah.
And it can't become law unless it's reintroduced and passed by the legislature. So
Okay.
we won't be doing anything.
Sounds good.
But the thing that I would add to
Yeah.
that is just like any legislative bill that it's identified to affect the practice of physical therapy, you'll see that it'll show up on this agenda. The board will have discussions primarily from the perspective of consumer protection. That last bill, and over the last 2 years of that legislative session, was a contentious conversation at this bill. You can actually go back to, I know you guys have like tons of choices for entertainment in your life with Netflix and Disney and Hulu and all that, but we have an awesome YouTube channel. Like you can watch board meetings going back to 2011, right? So if just look over the last 2 years, and I'm thinking one of the best ones is at the University of the Pacific, where we had a board meeting and we had a conversation regarding that bill and whether or not this board wants to support, amend, oppose, what have you. You get an idea of the perspective of the board and where their opinions come from and what angles that they come from. That bill it's an interesting bill in the sense that mandatory reporting is kind of a contentious topic in the sense that does mandatory reporting actually deter people from even coming and receiving healthcare services? That's an interesting idea, right? So it's definitely going to be something that if it's reintroduced in legislation in the future, this bill will still have discussions regarding it. And in those discussions, we would encourage anybody, members of the public, stakeholders, licensees, to come and participate in those conversations too.
Great.
I wanted to speak on that. I know that it came before us during two parts of the cycle. And I remember it was the second part. I do believe it was in Stockton that we did have a lively discussion. And I think that's one of those places where I truly appreciate the diversity of this board in terms of the representation from different aspects of the practice. And then, of course, our public members who are always reminding us that we are all consumers first and what it feels like or what the concerns might be if that was removed, or actually what the value might be if it was removed to somebody who was in that place. So I agree, go back and watch it and you'll hear a little bit, but it wasn't needing to be implemented because it didn't pass.
Great.
All right, guess I'm up. And yes, thank you very much for having us. We really appreciate the opportunity to ask questions. Mine has to do with promoting PTA, particularly as a career, especially for young people. If you look at the Bureau of Labor Statistics, it shows significant projected growth. And so I think there's going to be a lot of need, but I found this career path in a very roundabout way. I was burned out at my desk job and wanted to help people. So I looked at schools in the area to see, okay, what kinds of programs are there where I can help people and be on my feet? So that's how I learned about PTA. And back when I was in high school, yes, it was 20 years ago now, but they had us do one of those sort of classical assessments of what am I good at? What am I interested in? Here's some career options, several hundred options total, but I don't remember PT or PTA being on there at all. So yeah, just what, if anything, is being done to promote this as a career?
I'd like to start because thank you for asking that question, because one of the things that I was really promoting and asking that we do was to just what you said, just to make sure folks knew about PT, knew about careers in PT, knew what a physical therapist was, especially in Black and Brown and underserved communities where they don't hear this at all. And so we are doing something in this department, and I'm gonna pass it over to Jason to brag on behalf of me, okay, suggesting this and staying on it. And so thank you for your question. And Jason, it's all yours.
Well, there's a couple others down there that might want to speak too. You want to go first, or you want?
When I grew up, I didn't hear about physical therapy either. And when I teach in my current program, I always ask the students, how many of you have heard of physical therapy when you were in high school? And most of the hands go up, which is a great sign. So things are changing. We are getting the word out about physical therapy, but not to everyone. And so part of providing physical therapy services or being a physical therapy professional is service. And I always like to encourage everyone to go to high schools, go to career fairs, get the word out, let them know, especially if you are a Black and brown person, you could be me. I was you, no one told me I could do it, but I did it, and you can do it, right? So part of it is on us to continue to get the word out as well. Yeah.
Thank you.
Earlier yesterday, we did have a presentation from our outreach team about the high school presentations, and certainly there's so many ways to do that, and definitely different groups will show up differently. For our group, it was interesting because they're basically talking about how we regulate the profession and how we make sure that Californians are getting quality physical therapy care. And so speaking, and we can still speak as a board to the requirements for the degree, et cetera. But in terms of like the schooling and kind of all those other things, it's also very valuable to have input from people like you, but also the professional association too. So I think it's all of us, like she just said, and any opportunity you get to go back to your own high school and show up and be a champion for the profession, I think is valuable. They can see themselves in you if you came from where they came from.
Cool. I guess I'll put that on me then.
Well, I'll tell you that to President McMillion's point, this board has been on kind of a 10-year journey of outreach, right? And so I will tell you that when I came to the board, there were 3 PTA programs in the state of California, and there's now 28, right? Yeah. So to your point, the demand is higher. The advocacy for the profession, though, the responsibility for the advocacy for the profession lies at the professional associations level, the CPTA. Having said that, though, there is an aspect of advocacy for the profession that is consumer-based, right? It's an access to care concept. So to Tanya's point, as part of our strategic planning process, we've really focused on outreach for about the last 3 strategic plans. We got pretty good at it. We were doing a lot of program education. We'll come out and teach you about the role and responsibility of the regulating agency, walk you through the application process, have a whole menu of different types of presentations that we could present. But it was all very licensee applicant driven. We also want to be able to provide outreach for our consumers, to educate them on what physical therapy is, what they should expect to receive when receiving physical therapy services. And then we kind of entered into this new realm of, well, we're providing it to you as applicants in the program. Can we look at things like high school fairs and so on? So yesterday we presented that in October, we did 3 different high school events for the first time. So your question's very timely.
Great.
But it's also in alignment with the strategic plan of the larger entity that is the Department of Consumer Affairs. And what we learned in that experience is that now we're not just providing outreach about what physical therapy is, what the profession is, what the regulation of the profession is. These students in high school want to know so much more. They want to know about how we became state employees that regulate this profession, so on and so forth. So it's a new audience times 3, right? So we're kind of learning to craft our outreach as it is, but we've started and we're not going to stop.
Excellent.
So.
Can I just say one more thing? Because we have a room of PT assistant students. I think you're right. I think also, myself being a physical therapist, I think that there is a shadow, or that like people don't recognize that there's other things besides the physical therapist in the delivery of service for physical therapy. And I think it is up to all of us, but definitely you all, to promote why you love what you do and what role you play, and be the best, example that you can be. And I think that that will make changes for sure.
Oh, can I just do like a shameless plug based on that?
Yeah.
So Dave Dornan will hear me echo this in all the presentations I've ever done for his students. I actually have a slide in healthcare. When everyone in the room wears the title therapist, how is the consumer to know who's who, right? And so we talk about on our side in regulation, name tags, identification, highest level of education, that kind of thing. But you can take it one step further, right? And identify yourself at each and every point of the way, right? Ensuring that your consumer is educated and knows that you're a member of the healthcare team and you're here to help them with the, in assisting that physical therapist. I don't know that happens in a practical sense as much as it possibly could. And I think there's a ton of PR to be done on that side of it too. So
Interesting.
I want to ask Jason to please share the story that you shared with us yesterday about one of the students who came.
Oh, we did the Antioch Unified School District had a college and career fair day. So we had a table at this career fair along with the University of the Pacific had a table there, Army, military, Marines, Navy, the local colleges from around the area. And this young man came up to us and said, "So listen, I'm going to the NFL." And I was like, "Okay." And he said, "But I'm thinking, if while I'm in the NFL I get hurt and I had a physical therapy background, I could stick around on the same team and assist my teammates." And I was like, "Well, I see where you're going with that. I think that sounds like a plan, But then we also had to discuss that with his mother too, which that, is a different kind of conversation. So it was a really enjoyable experience, but it's very enlightening.
Any more questions from this first group?
Thank you guys.
Very much.
Thank you. Appreciate it.
Thank you. Group number 2. And if you can introduce yourselves and say what school you're from, and then we'll start the questions.
Hi, I'm Austin. I'm at SPTA, and I go to Institute of Technology.
Good afternoon, board. My name is Lawrence Crisball Jr., student physical therapist assistant representing Institute of Technology from Modesto.
Hello, I'm Vyacheslav Kurilenko, Sacramento City College, PTA student.
My name is Corey Romines. I'm a physical therapist assistant student at Sacramento City College.
Good afternoon, board. I just had a real quick question about nutrition. My question is, how does the board ensure that physical therapists providing nutritional advice stay within bounds of their expertise? And are there any established guidelines or insurance policies to manage liability risks for patients who may have experienced adverse outcomes related to the nutritional advice?
This would be a good question for them. We'll see how this goes.
I can at least speak to the component that has to do with what is the purview of a physical therapist based on their education and their ability to speak to the general population questions that are related to health and wellness. I know that our education supports the fact that we can have conversations with people who have high blood pressure about salt intake, and we can have conversations about people who have diabetes and maintaining their respective diet recommendations. I also know that if you happen to hold another license for another program, like if you were a dietitian or nutritionist, and something came up, you would have to default to the license that you hold that covers that, right? But I'm not sure that it's ever come up. because I'm new on the board, has it ever come up that someone has had a question or concern, inquiry about a physical therapist making a recommendation that was out of their scope?
Of course. I'm gonna go up about 10,000 feet in elevation, right? Physical therapy and PTA are both regulated under Division II of the Business and Professions Code, and that's where all of healthcare is regulated, right? The Medical Practice Act and so on. And in the Medical Practice Act, there's a cutout, a caveat, a section. California is one of those states where we don't have licensed nutritionists, and we recognize that most healthcare workers are going to be touching what a licensed nutritionist in another jurisdiction might be doing. And so in that Medical Practice Act, it essentially says that if you're licensed under Division II, you can give nutritional advice and even recommendations for certain supplements and those kind of things, but you have to post a disclaimer of some kind that you're not a licensed nutritionist, right? You have to educate the consumer in that information that you're providing to them is based on your knowledge, skills, and abilities, okay? Now, the question is, when that happens, when one of my physical therapists does that, is there liability there? And I will say there's liability in everything that you do practicing under the Physical Therapy Practice Act, right? Act within your knowledge, skills, and abilities. Be able to articulate what your education is, should a complaint ever be filed against you, to defend why you did what you did. And a good example would be like, if you don't know anything about nutrition, you probably shouldn't be telling anybody about how to, to do those things, in a very extreme explanation. And I think your question is specific to just physical therapy as a profession, not PTA specifically.
It could be both, just
Okay.
PTA and PTA.
So PTA would be a little bit different
Okay.
because that would be outside of scope, right? As the assistive personnel to the physical therapist, those recommendations would have to come from the physical therapist under that disclosure under Division II. It couldn't be done by the PTA.
Okay.
Now, you do have the ability to do health and wellness services as a layperson, but your consumer has to know that what you're doing for them or the services they're receiving are not being done as part of their PT plan of care, either from the physical therapist or the physical therapist assistant. A good example would be, you can be a physical therapy assistant and still be a wellness coach teaching Pilates in a studio. I can't stop you from doing those kind of things just because you also happen to have a higher level of education as a physical therapy assistant, right? The confusion comes into play when your consumer thinks that this advice is being given to them by you as the physical therapy assistant or your physical therapist, right? Outside of the plan of care, outside of the normal channel. Does that answer your question?
Yeah, it does.
Okay.
Thank you so much.
And then how to defend yourself on the liability? Always act within your knowledge, skills, and abilities. Always, in every aspect of your care. For PTAs, it's a little bit more specific. Your knowledge, skills, and abilities actually have to be documented by your supervising physical therapist. They have to have assessed what you're capable of doing and outline that in the plan of care. So you guys know.
There is professional liability insurance, so, I mean, that gives us some peace of mind other than just always doing the right thing. But there are plenty of times where I would make a referral out if I felt like someone really needed that education. So I'd refer to another healthcare professional. And then be careful as you move on and maybe become some sort of a special exercise person or vendor of certain vitamins or believer in a certain supplement that doesn't skew your view that every single patient should take it or that you're selling this to every single patient, right? So I've seen that happen too.
And then just in case if it is still of interest to you, under the Business and Professions Code, that law that we're talking about is 2068, nutritional advice. Yep.
Good afternoon, everyone. My question is regarding the physical therapy compact, and just to briefly kind of mention it to the audience, and please correct me if I'm wrong, board. I believe from my research that it's an agreement between multiple states where physical therapists and physical therapist assistants may work in these agreed upon states with ease rather than having to re-verify their licensure or possibly retest for licensing when moving to these different states. For example, in layman's terms, pretty much if a licensed PTA from Texas, graduates from Texas, gets their licensure there, they can also work in Arizona, Utah, and Oregon because of the physical therapy compact. Is that correct?
At a very simplified level, yes.
Gotcha.
So for the physical therapy compact in the United States, the only thing that I would add to it is that state has to be part of that compact, and then that applicant has to apply for a privilege to practice in that state by that compact commission, right? So let's say the Texas analogy still holds true. You're licensed in Texas. Utah is part of the compact. You have to notify the commission that you'd like to practice with that privilege in Utah, and you can't reside in Utah, right? It's like a temporary kind of practice. And it really becomes important as an access of care issue for states like Kentucky, right? Where there are so many border states to Kentucky, and you can literally walk across the street and be in a different state, right? This hospital is in Kentucky, this hospital is in Tennessee, and you're just going back and forth every day. So that's where it really does kind of benefit you as licensees, but it also benefits the consumer because that's an access to care issue, right?
And that actually leads me to my question about it in regards to California and the physical therapy compact. If it's something that would be introduced in the near future, or if there's like any reasons as to why it hasn't been introduced. Because I know states like Illinois, Michigan, and New York, they've began that legislative process to start becoming part of the PT compact, but not California.
Go ahead.
I'm gonna make my piece as the administrator, and then I'm gonna step out and let you as council and the members express their opinions. Two things is one is that would require legislative change, right? And so that change has to come from an author introducing a bill. The language has been presented by the Compact Commission in California once before. It didn't make it even to a committee where this board could consider the language. It died very early on in those stages. If this board was ever to be presented with that language, kind of the explanation that I gave in the last conversation about mandatory reporting, the board would have that conversation about whether it was appropriate, and that appropriateness would be rooted in consumer protection. Does this provide a higher level of consumer protection, or even maintain the existing level of consumer protection in considering whether or not the compact should be allowed in California? And then I'm going to step away and let them answer.
Thank you.
This is a very simple answer, and it is really not a smart answer, and that's the proper individual to contact there is your local member of the state assembly and the state senate. That is the body that, again, it's as an executive agency, we take our direction from statute and from the legislature. We do adopt regulations, but what that looks like is more sort of like, hey, board, we want you to do this. But you can do it in each of these ways, 1, 2, or 3, you pick. And then the board can decide some more specifics of that policy, but it can't just sort of make it up or add to state policy, even via regulation.
Who are the members to contact again?
You're a member of the state assembly and the state senate, which is which comprises the California legislature, the state legislature.
Another good point of contact is just your professional association, right? They might be interested in that and advocacy for the profession, and you might even find that they have scheduled legislative days where they're going to go to the Capitol and lobby for things like that. That's already good. One of the things that I was going to add to that is the idea of it being introduced and coming to this board. What we would be identifying is whether or not there are concerns with consumer protection, right? Mm-hmm. Something of note, just from compact language, period. Compacts have been around for a long time. I mean, your driver's license is a good example of a compact that's agreeable across the United States, right? If you have a California driver's license, you can drive in any other state in the union. You have to adhere to their laws when you do that, but it allows for that on a temporary basis, right? You're not a resident to that new state. I guess the other part that I would say in that is that if a state is going to accept compact legislation, the states have to accept the exact same compact legislation. There's no tailoring of the compact language to fit your state, because then that voids the compact language. So those states that you're talking about that have already agreed to it and are entering into it, if there's something in that legislation that is conflicting with existing California state statutes, it would make it very difficult for it to be implemented in that state. And that means any compact, commerce compact or anything like that. You accept whole cloth that new legislation.
Thank you for that. I appreciate that.
Great questions. This is kind of trial by fire. I love it.
Mr. Kaiser mentioned, we would want to pay attention to whether the compact would increase our level of consumer protection or even maintain it. And I would even add, might it decrease our level of protection in some ways? And so that's something that, an angle that we look at as well for the compact. It's relatively new, right? In the last 5 or so years, I think.
It's
A little
almost
bit
10
more.
years old.
Is it 10 years old? And so it's been an advantage, I believe, for us not to jump in and to watch how it all unfolds. And, it gets a little messy sometimes. And that informs us as we go on to whether or not we want to look at it.
Can we do another shameless plug? So California actually contributed in the drafting of what that compact legislation looks like.
Oh, wow.
Right? And there's been huge benefits across the United States as a result of that compact legislation. I'll give you a few examples, right? California has some of the highest standards when it comes to professional licensure, right? We do a criminal-based background check. We look into your history. And it turns out not all states do that. Some states don't do it at all. California has continuing education standards, a certain amount of hours. Well, guess what? Turns out not all states do that, right? California has a jurisprudence exam upon entry into the profession. We want to make sure you know and understand the laws that govern your practice. Turns out not all states did that either. That's in the compact legislation. So now every state that's agreed to be in the compact now has to do a criminal-based background check, have continuing education standards, and have a jurisprudence exam. A rising tide floats all boats, right? We just still have a few higher standards than even what the compact provides. So we'll have to address those issues when that legislation is presented.
Thank you for the clarification. That explains it really well.
I think one thing I was made aware of in this last opportunity I had to be at the Federation of State Boards meeting was the purpose originally, like you said, to create access. And I think that comes up when you're looking at states that may take a long time for you to transition and get your license in that state, and you're waiting. But since our board's quite efficient, that's not a negative on coming to California. If you have all of your paperwork done, our processing is one of the highest, fastest processings for those endorsed from another state. So access for that reason alone is not a reason enough if we already feel like we're able to process our applicants from another state pretty quickly.
From the administrator's perspective, instead of diverting resources to a new independent third body, if you will, with a licensed compact commission, who then takes resources and time, if I could invest that time, money, and resources into expediting our already existing licensure process, I would prefer to do that. I would argue we have done that, right? The times to receive licensure in California have been reduced exponentially over time.
Thank you.
Thank you very much for your time. It's a great honor for all of us. We appreciate it very, very much. My question is about PTA students with disabilities. How friendly is clinical field for such students? Is there any discriminations against such students? And how difficult is it to find a job for such students? Thank you.
Physical disabilities?
Yes.
Yes. So there are standards that usually programs have standards, technical standards that students need to be able to perform, right? So everybody needs to be able to make that mark. Then particular sites and particular settings may have their own. And so it would be the job, of course, of your director of clinical education, it's Millie, right? Millie? Yeah, it would be her job to find a site who can accommodate this particular student with this particular need, and here are the accommodations. if those accommodations come from the Student Services Center, right? So we need that piece of paper as well. But even without that paper, if there's just some accommodation, physical disability, that's not documented by the school, we can still, as the program, advocate and see if we can find you a site. It gets a little more tricky when it has to do with vision or hearing or that sort of thing. That's a little bit harder. But I mean, some students just need a quiet place to document so they can concentrate. So we can sometimes work on that. And sometimes we put that in the hands of the student to advocate for themselves. But if that's something we know is going to really put the student on a level playing field to be able to meet what they need to meet as far as the clinical expectations, then your DCE would be your advocate. Not sure if that answers your question.
Yeah, thank you.
Yeah.
I have two classmates in my program, physical therapy, that had disabilities and went through their whole clinicals, which were adopted to some degree to accommodate them, and then graduated. One was a paraplegic who ended up owning a practice now in the state of California, and the other one ended up, that person was legally blind and was able to do hand therapy and craft different types of splints in their clinics. So it's definitely possible. And I think it's just a matter of looking for those opportunities that match what what your skill set is and what you can contribute.
From the regulatory perspective, and that topic is sensitive to me, being permanently disabled, serving as chair of the Disability Advisory Committee to the Department of Consumer Affairs Director, you have and are entitled to any protection under the Americans with Disabilities Act, right? And similar to the kind of the nutritional advice idea, you are still expected to operate within your knowledge, skills, and abilities, right? And differently abled or disabled can happen at any point in your life. You could have gotten your license, already been practicing for 20 years and had a life circumstance that essentially limits your ability to practice this art and science. And it's your responsibility as a license holder to do that responsibility, understand that where your ability limits lie, and always practice within those abilities. It's to say that somebody who might be differently abled could practice outside of their KSAs and still be found liable for that. Now, the protections, like any other profession, lie within that American Disabilities Act.
Okay, and if you allow the same question about students who are over 50 years old, it's not a problem to find a job if you are young, beautiful, healthy, strong, but with your age, you are getting not as strong or healthy or beautiful. And if you're over 50, is it very difficult to find a job? How friendly is it? Please, thank you.
I think I'm answering the wrong question, but you did mention discrimination earlier, and
yes.
In the United States, there is an age discrimination statute. So individuals over the age of 50, that is the number, are a protected class, and that can, if you hire someone or don't hire someone specifically because of their age, that can lead to liability for them. And so most people do this more surreptitiously, but I had a case when I was in law school with someone I worked with that this fire department said we're getting rid of all these old dinosaurs and bringing some fresh, strong young people in. They got sued millions of dollars because they did just that, and they admitted it. So, forgive me.
When the discrimination exists solely because of the age and not a demonstrative level of skill or ability, then discrimination has occurred.
I would say that a more experienced person, more mature person, you have more years of life's experiences to bring forward and to apply to your patients. I think sometimes younger students, like right out of high school, right out of undergraduate at 22, who don't have those experiences, sometimes they're building those up over the next 10, 20 years. But, someone who's over 50 or just under 50, I actually think that's quite valuable. I mean, PTAs are getting jobs right out of school. You're still in demand. You're still valuable. So doesn't matter your age, doesn't matter where you came from. You've got some skills that are needed and you can contribute.
Thank you.
Hello, thank you for hearing us out. My question has to do with more of socioeconomic classes and rural societies, and if the board is doing anything to kind of help the demand for those kinds of class.
The short answer to your question is yes, but we have a very limited role in what we can do with that, right? Again, this also comes back to kind of that advocacy for the profession or advocacy for the consumer argument. Collection, if you will, of demographic or geographical data, gender, age, sex, any of those kind of things, if collected for the wrong reasons, can really leave, a bad reputation for a regulating agency. But where we know that that information should be collected by the professional association, they don't have the same access to the information that we do as the regulator, right? Your professional association has 10,000 members. We have 40,000 licensees, right? So they're only representing 25% of your profession. If we're trying to collect a real capture, in time of what that data looks like so that our legislators and our, leaders in executive positions can make decisions, we need a better data set to choose from. As part of your renewal, when you become a licensee, we're going to collect that data upon renewal. But we distribute that data to an independent government agency to create a database where that information can be touched by anybody. De-identified, doesn't categorize you in any kind of way. It just takes your statistics and puts them in that database so that those decisions can be made. All the way down from sex or gender or age to geographic location. Where are you located? Is that an underserved area? And if it's an underserved area, can those legislators or those lawmakers now make new policy decisions to kind of spur growth for access to care in that area? Or is it even necessary? Do we actually hand that to the insurance, third-party payers and the professional associations to advocate for that? We also have, through the Office of, or OSHA, the Office of Safety, Health and Safety, there are actual stimulus, if you will, as a licensee. If you're willing to commit to serving in an underserved area, there are, what's the word? We were just discussing this yesterday.
Incentives?
The incentives, and then actually the student loans can be forgiven.
Student loan forgiveness, but also even part of your education now. So you can actually sign contracts with a commitment to serve in an underserved area to receive financial assistance towards your tuition or to student loans. So there are some things that government can do to help with that. But we also don't want to be seen as collecting data for the wrong reasons, right? And so that data is de-identified and given to an objective third-party government agency.
I love this question. So love this question. But with my specific board hat on right now, I would say that the value of the board in this area is to make sure that the consumer in the middle of Fresno gets the same quality as the consumer in the middle of San Francisco. Right? And that they know that, and that our role then is to educate all of our constituents, all of our consumers as to what physical therapy is, what's quality, what to expect. And maybe we do that in a different way to make sure we get our outreach out there. Maybe we do that in different languages, right? To make sure that we have truthfully done that part of our job.
An example of that would be as a licensee, your physical therapist is required to post a notice to consumer that basically identifies that they're a licensee of this board, and we provide that document translated into 8 different languages. So depending on what community they're providing those services to, they can post it in more than one language.
Thank you.
I like this question because it actually sort of put as a board we're consumer protection, but it does, as far as patient access is concerned, that it is part of the board's also preview of it.
responsibilities. So, however, the main push from at least my personal perspective is going to have to come from you. You know, candidates like you guys, as part of the industry, healthcare industry, you are the one need to be the advocate, and through your associations, and to build that communication with the consumers, right? The underserved communities. The schools can help with that also, right? In terms of coordinating placements and doing outreaches to those organizations that are providing services in the rural areas, in the underserved areas. I think that's where I think the power is coming from, right? And also from there are programs that the government as a whole is trying to address, is to provide incentives like tuition forgiveness, assistance, or if you have borrowed money and then if you stay in certain geographic areas that's defined for a number of years, and then your entire loan can be forgiven, right? So the climate is great right now because for any healthcare professionals, right? We're talking about integrated care right now. We're talking about multidisciplinary care right now, which you guys are part of it. And the rehab option nowadays is what the healthcare industry is emphasizing on. That as part of that, you're going to be a very essential part of that team, that healthcare team. And all of those benefits will help to build a healthier and actually a very fulfilling profession for you guys. But that takes active involvement, just like what you're doing right now. Okay.
Just two things to add to that. So that program that I mentioned is the Allied Healthcare Loan Repayment Program from HCI. So if you guys just look up hci.gov, you can get there. There's a number of different programs right now. The cycle's closed, but this is something that kind of opens and closes as funding allows. And then another shameless plug, that notice to consumer that we were talking about in that regulation, right, where you either have to have that notice to consumer conspicuously posted somewhere in the practice, or in settings where that's not allowed, you actually have to have it handed to and acknowledged in the medical record to the consumer. Shamelessly is our way of exploiting you as licensees to do our outreach, right? Because you're there face to face with the patient. You have a unique point of access to educate them on the profession of this, or the regulation of this profession, right? So that requirement is there, one, to legitimize the profession, but to provide that education to those consumers, and we hope that you help us with that.
Thank you.
Thank you.
Thank you so much.
Thank you.
I'll also just start off really quick that each one of you sat down and thanked us for the ability for you to come to us today. And I want you to know, just speaking on behalf of the board, it's our pleasure, right? We've been trying to do this for a long time. This is the largest group that we've ever had in attendance. So thank you for coming.
Hi, my name is Janine Brown. I'm from IoT, and I would just like to thank you for having us out here today. We appreciate it. Okay, perfect.
Thank you very much. My name is Alec Crawshar. I'm a physical therapist assistant student over at Sacramento City College.
Thank you for your time. My name is David Welch. I'm a physical therapy assistant student at Sacramento City College.
I just had a question, please, about the statute AB 1991. As far as mentioning the National Provider Identification, the NPI number, it states that there's no crime if it's not available or provided, but can you please explain how this ruling is to be applied in the PT setting?
So we kind of talked about that renewal application where we're going to ask you for some demographic data. And so currently in the renewal process, we ask for the NPI number, but all of the questions that we ask, whether they are protected class questions, demographic questions, or geographical questions, you're offered the option to not answer, right? That's including the MPI number. Well, there is no database that actually correlates licensure to MPI. So the state governments have said too many people have opted out of answering that MPI question because really you're in the middle of your renewal, right? You're just renewing your license. You don't know your MPI by heart. You don't know where it's at. And people are quick to just check decline to state. Well, that made for a very unreliable database. So the legislature has come forward and said, we're going to remove the decline to state option for MPI. If you don't have it, there will be a directive of what number you can put in its place to indicate that you don't have it.
Okay.
But you'll be required to put it there now. And again, to that question about what are we doing about underserved areas, how do we coordinate, access to care and ensure that there's adequate care being provided in certain areas, that's one of the tools that they need to do.
Okay. Thank you.
Yeah.
Just like how the physical therapist education has kind of progressed from a bachelor's to a doctorate. I've heard talk that a PTA will eventually become a bachelor's. I was wondering how close that's actually coming, or if at all, and if so, is that going to expand the roles of a PTA?
I don't know. That's my answer. I don't know how close that is. I would take a close look at what happened for the physical therapist and how that license has moved up the chain to a doctorate. And I can tell you that I don't believe the pay has changed any. Yeah. And so, you may want to investigate that and see what would be the benefit to you. You might want to see what would be the benefit to your profession. And if you've got strong opinions, then you've got to get in on that conversation when the call goes out for public comment from your association or what have you. Get involved and say what you think should happen.
I will tell you, just for context sake, if we were having this conversation 20 years ago today, and it was in that context of, is the physical therapy profession going to be moving to a doctorate level of education? The board would have answered the same way. I don't know. Right? And that's the evolution of just the profession as it moves forward. Academia usually goes before regulation. It's hard to predict, right? It's kind of a market indication, and that's usually the driving force. So whether or not we think that your level of education needs to be raised, again, everything would be based on, is it necessary to ensure consumer protection? And right now, I don't have any statistics or data that supports the idea of, oh yeah, they have to be moved to the bachelor level of education.
Thank you.
Actually, my question was very similar, but instead of asking that, I'll ask, is there any room within the physical therapy field of practice to add a bachelor's level? Kind of how there is with nursing, how we have the licensed vocational nurses, bachelor's nurses, masters, and then you go up to doctorate. So is there room for a bachelor's level in keeping with the licensed vocational level?
So would there still be physical therapist assistant and physical therapist? Are you asking, is there going to be something in between or below?
Correct. Is there going to be something in between? Does the board believe there is room for a position in between physical therapist assistant and physical therapist, seeing as how it's moved from a master's to a doctorate?
I think you identified it. It's almost a similar question, right? And I think it comes down to that kind of evolutionary process of the profession itself. Nursing is a good example. Sometimes that level of education just becomes a benefit in business at that point, competitively speaking, right? You have a higher level of education than the same license type that you're competing with. That might give you a unfair business advantage. Whether the board thinks that there's room for it or not, again, really comes just down to, we wouldn't be opposed to you having a higher level of education. Do you need it? And is it necessary for consumer protection would be where it comes into the context of this board's jurisdiction. I might be talking out of turn, but I think there are bachelor PTA programs being experimented with in the United States. as part of that bridge from PTA to DPT. So again, experimental, but that's kind of how academia works, right? Like even when we transitioned the PT from master's to doctorate, it had already been accepted at the doctorate level as a kind of a business advantage, and then it became the standard over time.
Yeah.
So it's possible. We just don't know when.
I think one of the things that I've realized over time is that it's really the market that drives a lot of that, whether it's education cost or reimbursement, which again doesn't speak to this board. It speaks to the bigger picture. So I would definitely circle back to association questions and getting a idea of what that looks like across different states even, you know. But at the end of the day, it's usually the association, the larger national association that's gonna that APTA and the CAPTA, yeah, that's gonna determine kind of where the profession itself is going and why, and what those driving forces are. And our job is to make sure that it doesn't change the quality that's implemented when they make that decision.
Thank you.
I think looking back at the history and the movement of how PT transitioned from certificate to baccalaureate to master's to doctorate, and just kind of understanding where those motivations came from, who drove them, those kind of things, you'll see that model kind of mimicked across all of healthcare, right? And so to Dr. Brandon's point, very market driven, very advocacy for the profession driven, and sometimes maybe not having the end result that was being sought, right? Moving to a higher level of education doesn't necessarily mean a higher level of reimbursement. So you might be investing more, and it might take some time for the market to catch up.
To that investment.
If it, well, yeah, if it does, or
Kind of
when it
similar how
does.
You were saying that pay hasn't shifted much from master's to doctorate. Okay.
About 50% of our licensure population right now entered into the profession with a doctorate level profession. That's how kind of new this is, right? So about 50% still had the master's or even the baccalaureate or even the certificate. We have some PTs practicing in the state with double-digit license numbers. It's impressive, right? Since the inception of the doctorate level, about 10% of the licensing population that had a master's then went on to get a transitional DPT, right? To advance their career, to advance their knowledge set, invest in themselves. So still, currently today, only 60% have the doctorate level and still practicing in California.
Got it.
So.
Thank you.
Thank you. We have 4 available seats here.
Don't be scared.
Share your name and your school.
My name is Rose Vang, and I'm a physical therapist assistant student at Sacramento City College.
Hi, thank you for the opportunity. My name is Mary Kay Yukina. I'm a student, physical therapist assistant student from Sac City College.
So my question is similar to the disability and accommodations question that was just asked. But as a person with a hearing disability, I'm just kind of curious how does the physical therapy board help include physical therapist assistant with disabilities in regulatory decisions about accessibility?
Oh, that's a very good question.
And also, if you guys could speak a little louder for me, I would be appreciated.
Thank you for making the point. It's a very good question. I think the way the question is phrased in what are we doing to encourage? As bad as this sounds from a government agency, we're not doing anything to discourage, right? So all voices should be heard, all voices that are willing to participate in the process or move forward. As an example, for this meeting, if anyone made a request, we would provide, assisted listening devices and those kind of things and have them available to you. We kind of touched a little bit about this earlier when we were talking about ADA accessibility.
Right.
So as part of our report, we reported that our website, as an example, right now actually passes an ADA accessibility audit, meaning that all of the content that's provided on the website is accessible for those that are maybe vision impaired and are using a software reader. All of the discipline documents and those kind of things, which are typically just pictures of documents, have now been converted so that those with vision impairments can actually use that reader to read through those documents. Our publications that we post out, all of those kind of things we have to adhere to. So again, it's not so much encouraging as that we're doing everything we can to be as inclusive as possible to allow for that participation.
Yeah, if I could just clarify a little bit on that or ask for clarification. Do you guys consult with possibly physical therapists or physical therapist assistants with disabilities regarding new regulations, or do you guys speak with an advocacy group regarding creating new regulations?
So I think there's a couple layers of protections that are in place there. So if we're talking about like the promulgation of any new regulations or laws, aside from that public participation where we're asking for stakeholder involvement that might include those kind of concerns, we also go under a scrutiny review from an Office of the Administrative Law, right? And so they're going to look at any kind of regulations that are being sought or promulgated and making sure that they adhere to not only our Practice Act, but all of the other acts, including the Americans with Disability Acts and those kind of things. And I can't think of a regulation per se that restricts the practice of a physical therapist or a physical therapist assistant that might have like a more detrimental effect to somebody who has a vision impairment or a hearing impairment. They're all about standards of care, right? And it's really from the consumer side of the perspective is that the care being provided to the consumer meets a certain standard. We kind of touched on Americans with Disabilities Act, on admissions to schools and those kind of things, and that a practitioner still has to operate in their own knowledge set, skill set, and ability set. Meaning, as if we relegated it to something as simple as driving, right, and your driver's license, there may come a time, for me, more and more every day, that I might not be suitable to drive a car anymore because of my ability to see. Right? At some point, the law has to cut me off and say it's not safe for the people around me to continue to drive. And you can use that same standard when it comes to a healthcare practitioner. Doesn't necessarily mean that they have to stop healthcare altogether. They just have to understand their own abilities and any kind of limitations, therefore.
Thank you.
I have a couple questions about the PTA to PT bridge programs. So I wanted to know the stats for regarding the employment and their licensure outcomes for individuals who complete the bridge program in California, the current statistics, and are they flexible, or how's the flexibility with those in order to accommodate those working as a professional or specifically as a clinician or as a PTA? Are they required to pause to work as a PTA or while getting enrolled in the bridge program?
Well, I'm gonna ask the two educators on the board to opine, but I will say we're not aware of any bridge programs in the state of California. There are a few experimental bridge programs, Midwest,
Texas.
There's always the natural progression that once you become a PTA, there's nothing that hinders you or stops you from then also entering into a DPT program in the future. There's no requirements that I'm aware of that would say you have to stop practicing as a PTA while you go to school for your DPT. I think that's going to be kind of more of a college policy kind of situation and time commitment issue. But there's nothing on the regulatory side that would prohibit that from happening. And then for the bridge programs, if they're licensed in that other state through a bridge program of some kind, we might have to look at that program and whether that license is transferable from that state to the state of California, right? And again, we haven't had that opportunity yet because it's so new.
Yeah, I don't really have much to. I don't have much to add other than I know programs, DPT programs, do consider the rigor of courses taken at a physical therapist assistant program versus the rigor in a doctor of physical therapy program, and so I think the rigor might just be at a doctoral level for a physical therapist program, and that might be why the courses are not transferable from the PTA program.
I think you can look up on the national PT exam data what the passing rate is for the bridge programs versus the non-bridge programs. And that will give you an idea for the few offerings of bridge comparative to like if you just started from scratch and saw what was still approved for an entry-level DPT. But I think, coming from an academic side of things and being in a program where we accepted into the entry level, some PT assistants that had been in practice, there was so much value to their knowledge and their expertise. And I think the biggest challenge was that maybe they have a different role when they become a PT student. And it's kind of like relearning how to approach the patient. And there are things that they were incredible about because they had some handling skills already. They definitely had some patient interaction skills that other students didn't have. But then just remembering that this is now a different role. And that goes both ways. That goes if that person was still practicing in a hospital and just because they learned to do a mobilization or something specific to the PT's role, not bringing that to their practice because they're confused. In one role, they're the student of PT. In the other role, they are a PT assistant licensed, right? And then the other way is helping them recognize what was different about this new area of the practice as they become the physical therapists in charge.
The only thing that I'd add to it too is for the board to consider bridge programs in the future would require a legislative change, right? So right now, the Practice Act speaks to CAPTE accreditation, but it specifies what the content of CAPTE must accredit it. And that would change that substantively enough that it would require a legislative change for CAPTE to have a bridge program that would be accepted in the state of California for the purposes of licensure. So a good model to look at would be bridge programs that go from licensed vocational nursing to registered nursing or registered nursing to nurse practitioner and just see how those programs have evolved over time. And really, they're just entering into that conversation as well.
Thank you.
Thank you.
Any further questions? Yes.
Sorry, I always have questions. Okay, about injuries at the working place. The population is getting bigger and heavier. And when I work in a hospital and see a therapist who is 120, 30 pounds, working with a patient who is 3, 4, 500 pounds, I'm always a little bit concerned. So is there any kind of protection or insurance that covers such accidents, incidents at the working place?
And when you say coverage, you mean covers the licensee in the matter?
I mean that you're working and you got disabled. What happens next?
Yeah, it would be a workers' compensation issue. The board doesn't have a lot of jurisdiction in that role, but there is a liability side of that, right? So from a practitioner's perspective, where your patient may outweigh you 2 to 1, there are safety concerns, right, when it comes to transport and transition and all of those kind of things. And we, for licensees, have an expectation that the licensees are able to kind of identify their own limitations and then adjust accordingly, right? So if you think that it's not safe in that situation, we would encourage you to follow your instincts, have another aide or a PTA or PT assist you or any other member of the faculty at that particular clinic or something like that, so that that transition is done safely, not just for the consumer, but for you as practitioners as well. Right? But on the insurance side of it, I think it comes down to basic employment insurance at that point. If you're injured on the job, you have a certain set of statutes that protect you, not necessarily, confined in the same statutes that your Practice Act is in.
I think when you see a situation or you encounter a situation that you are even second guessing, thinking this could be unsafe, ask for help. That's the bottom line, is to ask for help. Yeah, because I might be concerned as well in the scenario that you described, although there could be someone who is twice as heavy as I am, but I do an assessment, they're moving well in bed, they sat up on their own, and I made an assessment, I feel good that I'll be able to walk with this person, what have you. Then again, as a physical therapist assistant, maybe I'm your supervisor. This person's appropriate to be followed by the PTA. This person walked with me with contact guard assist. You go the next day in the hospital and try to get them up, and they're dead weight. Call somebody. Call the nurse. Call the physical therapist. Something's changed. Yeah.
Thank you. I appreciate that.
I think there's still some faces out there that we haven't heard from.
Do you want to start pointing out? No.
I've got staff out there that can just raise their hands for them. No, I'm just kidding.
Any further questions? No. Well,
From faculty?
Sure. You want me to come up here or just yell from here? I'm loud.
Honestly, Dave, you could do either one.
Honestly, you gotta come to the mic.
All right, I'll come to the mic.
Name and school, please.
Everybody knows who I am and where I'm from. Dave Dorn, Program Director for the Sac City PTA program. You guys changed over to doing the jurisprudence online. What has been the impact in doing it that way versus doing it through Prometrics?
Almost all the impact's been beneficial to everyone involved, right? So there's a couple things with the jurisprudence exam prior to July 1. It was given the very same way that the National Physical Therapy Examination was given. So you would register with a Prometric center, very high security, high risk assessment of the exam, fingerprinting, all of those kind of things. The only difference is it wasn't fixed date testing. You could book an appointment, but it's still not as convenient as what the JAM is today. The JAM today is you can take it at your own convenience online from the comfort of your own home in your pajamas with a cup of coffee. It's more of an educational tool in the sense that, and Dave knows how I feel about this in outreach, is that you will spend a lot of time learning the art and science of physical therapy and a very small snippet about kind of the governance of that practice, right? And it's kind of our job to shove our foot in the door because there's no CAPTE requirement that Dave has to provide to you as part of that education other than ethics and legislation, right? Because they don't know, honestly, that you're even going to stay in the state of California. So why teach you about the application process? Why teach you about the California Practice Act? You might be going anywhere, and that's for any school in the nation. It's up to us to try and make you more informed applicants, more informed students that become more informed licensees so that we see a greater outcome down the line. So when students were taking our jurisprudence exam, even with our outreach efforts, and I mean, we tried a lot of things. I'd come out to the schools and hand you guys books. If you ask good questions, I'm like, here is a hardbound copy of the Practice Act and all the laws that govern your practice. And I would warn you, don't sleep on the California law exam, right? And for a good portion of time, the pass rate for the California law exam was lower than the National Physical Therapy Examination, even for assistants, right? So we looked at that and we said, we need to change the way this vehicle is delivered. And so now you take it online, and we realize that it might be your first exposure to those rules and statutes and how do you read these things and how do you interpret them? How do you get through the legalese? And we ask you a question. And let's say you get the question wrong. The test itself, the software itself will be like, close, but you got it wrong. Here's the reference material. Read it and try it again, right? To try and anchor that learning portion of it. If you get it wrong the second time, you got it wrong. You score it wrong. However, it will then tell you what the correct answer is, because as the administrator, I need you to leave that examination knowing what the correct answer to that question was, right? What's resulted in that is that we've seen an increase in the pass rate. That was anticipated. We want this to be a more learning and educational tool than an actual examination per se, especially not a high stakes, high security examination. The other benefit is it's cheaper, right? It's about half the cost of what you guys had to do when you were taking it at a Prometric center. It's more convenient for you. It's more convenient for us in the transference of your scores. It's more real time, so that it expedites the licensure process just that tidbit more. And it gives us a little bit more access in the development of the exam itself. So if we see trends or we see questions or we have regulatory changes or statutory changes that need to be accounted for in the exam, it's a lot less effort to make those changes in real time than it was when it was that psychometrically sound, high stakes, high security exam. And correct me if I'm wrong, you've participated in the development of my exam in the past?
No, I have not.
Not as okay. We're doing it right now, or we have to do an occupational analysis, and we have licensees come in and serve as expert consultants and take apart the National Physical Therapy Examination and the California Law Examination at the same time, so that we can build, again, a psychometrically sound exam and determine whether there are voids or deficiencies in the current process. And it's something we have to do about every 5 to 10 years, or depending on how quickly this profession advances. We also have to do it upon need, right? If there's a huge, significant change in your practice, we're probably going to have to reevaluate and redo the exam again. So,
Last part of that question would be, as the program director, is there a way that we can actually get the statistics in regards to the performance?
We're already publishing them.
Okay, where would I find those?
So there's two things. One is we're going to publish them not on a program-specific basis just yet.
Okay.
We have that access and data available to us from the Federations of State Boards of Physical Therapy. So as soon as we actually categorize and kind of sort that data out, we can distribute them to you.
Yeah, that our school would like for me to have that as part of our review for every
absolutely
every program review every 6 years. So, and then in regards to the bridge programs, they're Ohio, Mississippi, Texas, and Wisconsin are the four. Just figured I'd let you know.
Excellent. Thank you for that.
Okay, any public comment?
So no more student comment and no public comment either? All right, whatever.
Well, I'm gonna open the floor to board members to have any final comments or statements to this magnificent groups who have joined us today. Good final words.
You are the future of our profession. Glad you chose our profession, and good luck.
Board members, final statements. More than Alicia.
I'll just say what I said when I became a board member here. I think the best way to protect the consumer is to do your best, to be your best, and recognize that, that you're not doing this alone. You can always ask for help if you have a question about something you don't remember after you graduate, you've left already. Contact our board to see. Some things seem gray to you when you're in clinical practice, and we can at least assist you in understanding the laws that we practice under. So you're not alone, and we're not out to hurt you. We're out to help everyone. We're out to help your grandmother and your sister and your best friend when they get care, to make sure that they're getting what everyone deserves.
So I am one of the public members on this board. And when I was appointed to this board, I really did not know much about physical therapy. And in my time on this board, I have learned so
much about the work that my fellow board members do and about the work that you guys are working so hard to do. I had my first physical therapy service provided to me earlier this year. And when I tell you, it was amazing. The young lady who worked with me, on me, I walked in with an idea of what to expect. And she did above and beyond what I was expecting. And so I just want to take a moment to applaud each of you for choosing this field, for showing up today and just giving me more hope and more respect for what you guys are doing. The future looks amazing from my perspective today. So thank you so much. Thank you guys so much. And I hope that if I ever need services and you guys are anywhere near Compton, I hope I land in your arms to take care of me. So I really appreciate you guys showing up. Thank you. And with that, did you want to say something, Council? Okay, so with that, thank you guys. And we are going to take a 10-minute break and then we will come back. What time? I always have to say, what time is it? I feel like crying. Like, you guys just really touched me today. So I really appreciate you so much. So it's 2:40?
Mm-hmm.
Okay, so we will resume at 2:50, 10 minutes. Thank you, guys. Mr. Canotes? Mr. Canotes?
Chocolate monster?
We're starting.
We're ready. Oh, I know. Way. Okay, so we are now at agenda item number 23, public comment on items not on the agenda. What I miss? 22. We're doing, oh, sorry. But I thought okay, I was, so I can. We're rolling with it. Agenda item 23, public comment on items not on the agenda. Hearing none. Now we will move on to agenda item 22, board member elections.
So at this point in the elections, as tradition kind of dictates, we are looking for nominations for board president moving forward in 2025.
Mm-hmm. In duties of the board president? Did you want us to talk about that?
I had a formal question. The formal question was, is there any information available in our administrative handbook regarding the explicit duties of the president and vice president?
There are in the administrative handbook, they are kind of peppered throughout the handbook what the president's role is in each aspect. But we have had conversation about creating kind of a sheet for onboarding of board members as they're appointed, that we could kind of create a new sheet that specifies those out specifically to the president's role and even again for the vice president's role. I think you have an advantage today in asking that question because there are two, a current board president and a former board president that can answer some of those kind of questions and concerns more specifically. Hopefully they'll help you out.
And I think that creating that sheet, handbook information would be a great thing for the new president to do. Whomever is elected. Okay.
We will make sure we try to put the communication in that document. Does that answer Dr. Brandt's question?
I think that, yeah, including the description, the responsibilities role, and also kind of the term and all that information would be in that document. But no, I absolutely would love to hear from those who've served in that role and kind of what their experience has been, and if it's been a growing or kind of a dynamic role based on personalities that are in there and all that. That'd be great to know.
I can go first, and then you can bring us up to date since you've been here for 2 years now in this role. And so I tend to believe that each person has their own style, right? And will make the position what it is based on what they can do and what's expected of them. So I don't think any two presidents will be the same. Of course, you're overseeing the overall board and how it's running. You have a direct communication between board members and the EO. You are going to be signing disciplinary orders. You're going to be signing letters that we might support, oppose, what have you, to the legislature, the authors. And then there's a whole bunch of things in between. You'll be approving the travel, that sort of thing. And so it might sound like it's a lot to do, but it's doable. It comes in small chunks at a time. One of the things that I really liked was having regular meetings with the executive officer. We'd like to do them every week, but that didn't always happen. Sometimes it went longer than every week, but we definitely kept a good line of communication. That would be important.
And I am so grateful to have Alicia and have Michael on each side of me, like seriously holding my hand, because the first year there's a lot that happens behind the scenes that folks are just not aware of. And when you're in this seat, it all the pieces make sense. And the role that you play, it's important. And it is a lot, but like Alicia says, it's doable. But I'll tell you the most difficult part for me, and this is just everybody had their own, each president I'm sure had their own challenges. But for me is the president's message that's for the newsletter, and following behind Katerina, following behind Alicia, and it was just so challenging. And I thank God for Jason and staff. And girl, let me tell you, his team, they are there for whatever questions you have, whatever needs you have. There's a lot of help for anybody who is voted into this seat. And so it's been an honor. It's been an honor. So that's my take on it.
I can speak a little bit to like roles and responsibilities of the board president in consideration of just serving as a board member also. Right? Because really as a board member, there's still a time commitment, right? With case review and all of those kind of things, training, documentation of training, travel, claims, all of those kind of things, coordination with meetings and all of that. We appreciate it. We know how much it can affect your personal lives and your professional lives, and myself and staff will always be there to assist in any way. But it is a significant bump from member to president, and vice president for that matter. So agenda creation, steering the board in the direction of the strategic plan, all of those kind of things ultimately fall on that board president as far as leadership. I appreciate the presidents that have served for me and the commitment that they've given to me. To Dr. R.A.'s point, that idea of that weekly communication is just as invaluable to me. I need it, right? I need to be able to check in. And while it might be weekly, it's just kind of a normal calendar. It could be every other week, right? It could be every day, right? There are some times where demand just asks for it. And it really depends on where we are and what kind of issues that we might be dealing with at the time, where we are in the legislative session, where we are in the application season process, where we are in consideration of new initiatives that are being employed by the department above us or the agency above us. So there may be times where the president is asked to come to the Sacramento area, to go to the Capitol, to discuss topics. And so those are only things that I would say is in consideration, is it is a little bit more of a significant time commitment and involving the vice president along those ways as well.
I want to add one more thing. You've been a witness, everybody's been a witness to me leading these meetings. And yes, I have not completely fully grasped, everything, but nobody made me feel dumb or less than smart or, ill-equipped. Like, I really appreciate that, because you would think that being on this board and doing these meetings, like you would just know how to run this thing. No, it didn't happen for me. So I do appreciate, not feeling a certain way.
I think you were a fantastic president, Madam President.
Thank you.
I don't. Yep.
You are someone to be emulated because of your humility and because of all of the heart and wisdom you bring. Really appreciate you, Madam President.
I might be biased, but I will say that you are a high-performing board in totality.
Yeah, we are. So can we start with nomination?
We are looking for a formal motion of a nomination for board president for 2025.
I want to nominate Dr. Karen Brandon for president.
Second.
Dr. Brennan, do you accept that nomination?
I will accept that nomination. I need everybody's help if I accept this nomination.
Any discussion? Do we vote on this?
Public comment? Hearing none. Vote.
Oh, yeah.
That's how I run it.
Thank you. Let's vote.
I believe the motion is to elect Karen Brandon as president of the board. Tanya McMillan.
Aye.
Dale Armstrong. Dale Armstrong is absent. Karen Brandon.
Aye.
Katarina Ellaby. Katarina Ellaby is absent. Samuel Q.
Aye.
And Alicia Rabina Amen.
Aye.
All right, unanimous for the members that are here.
So moving to a formal nomination for vice president for 2025.
I'd like to nominate Sam Q.
I second that.
Any further discussion? Any public comment?
You have to let him talk.
No. Okay, fine.
Point of procedure.
Okay, thank you.
Gosh, it's this is the fastest promotion out of
So I'm assuming, Mr. Q, you're accepting the nomination?
I will accept.
Thank you.
I had
That's
accepted
great.
for him.
Okay.
Okay. All right. The motion is to elect Sam Q as vice president. Tanya McMillan.
Aye.
Dale Armstrong. Dale Armstrong is absent. Karen Brandon.
Aye.
Katarina Ellaby. Katarina Ellaby is absent. Sam Q.
Aye.
Alicia Rabina Amen.
Aye.
All right, it's unanimous. Motion carries.
So the next nomination we're looking for is delegate for the Federation of State Boards of Physical Therapy for 2025.
I'd like to nominate Tanya McMillan.
I second that.
I accept.
Thank you.
You're welcome. And any public comment? Board discussion? Let's vote.
The motion's to elect Tanya McMillan as the FSBPT delegate. Tanya McMillan.
Aye.
Dale Armstrong. Dale Armstrong is absent. Karen Brandon.
Aye.
Katarina Ellaby. Katarina Ellaby is absent. Sam Q.
Aye.
And Alicia Rubina Amen.
Aye.
It's unanimous. Motion carried.
All right.
Now looking for a formal motion for alternate delegate for FSBPT for 2025.
I'd like to nominate Dr. Dale Armstrong.
Second.
I believe Dr. Armstrong would accept the nomination.
All right. Can
Public comment?
we? Yeah. Vote.
The motion's to elect Dale Armstrong as the FSBPT alternate delegate. Tanya McMillan.
Aye.
Dale Armstrong. Dale Armstrong is absent. Karen Brandon.
Aye.
Katarina Ellaby. Katarina Ellaby is absent. Sam Q.
Aye.
Alicia Rubina Amen.
Aye.
Unanimous. Motion carried.
Yes.
So the next one is a little bit different. What we're usually looking for is should a delegate or an alternate delegate not be available. Traditionally, what we've done is gone down the line alphabetically for the next available board members, and we swap every year. We change it from A to Z to Z to A, and kind of go down the line. The composition of the membership is going to change in 2025 substantially, and I would say, given the elections that happened today with delegate and alternate delegate, I think it's just safe to say, not knowing who the new members are going to be, that we can just move with an A to Z alphabetical understanding with everyone who's going to serve. If that is acceptable to you, that's the recommendation we would make from staff. And so if we had that as a motion, we would have to second it and vote it.
So moved.
Second.
I'm sorry, what's the order for the
A to
motion?
Z.
A to Z.
Okay. Okay. Any public comment? Let's vote.
So the motion is to have the other members as the FSBPT backup delegates in alphabetical order from A to Z. And are we ready to vote?
Yes.
Okay. Tanya McMillan.
Aye.
Dale Armstrong. Dale Armstrong is absent. Karen Brandon.
Aye.
Katarina Ellaby. Katarina Ellaby is absent. Sam Q.
Aye.
And Alicia Rubina Amen.
Aye.
All right, unanimous. Motion carried.
Thank you. Yes. So, agenda item number 24, agenda items for future meetings. Our next meeting will be March 18th through 19th, 2025 at the University of the Pacific in Stockton, California. Do we have a closed session? Anything? No, we don't. We did it. Okay.
There's no closed session today.
So, any agenda items for future meetings, for the next meeting?
Maybe something for consideration might be a presentation regarding AI in any way that it might affect the board. I heard that there was much talk about it at the meeting, and so if there's anything that's of interest that the board might want to keep their eyes out for, ears out for, that'd be great.
We'll certainly look for that kind of on an informational basis. We might be able to do some collaboration with the department and see if there's any kind of other interests with other brothers and sister boards so that we can kind of combine resources and bring that to you.
Thank you.
Beautiful. Okay, then I think we are done. Meeting is adjourned at 3:08. Yay.